Well, I'm mentioning for one matter for my lord admission on 11 February. One notice was served upon us for land compensation.
11 February.
Yes, my lord.
Okay.
Actually, solutions I put for listing two motion matters, my lord, day after tomorrow, my lord.
Day after tomorrow.
My lord.
4th.
Fourth.
When did you file it?
One is filed on 21 of January and another 29th of January.
All right.
Day after.
My lord.
God bless you.
Similar prayer, it was filed on 19, my lord. PRC matter, my lord.
May please prepare for listing a fresh matter, lordship, we filed on 20 January 2026. Next.
Friday?
Friday.
Coming Friday? Yeah.
That mention for orders listing.
Orders.
Madam.
11?
Madam,
11?
or 13, madam.
13 only.
Published.
Madam, I am paying for listing of a matter in admission column next week, any date.
11?
11. Okay.
May it please your lordship, with consent of the other side, lordship, I beg to mention item number 26, lordship. Lordship, in this matter, respondent has filed affidavit. We need time to file affidavit, reply in affidavit.
You're for the petitioner.
I am for the petitioner, lordship.
How much time do you want?
Lordship, 2 weeks.
26 at the request made by counsel for petitioner be listed after 2 weeks.
Obliged, lordship.
May I please, your lordship? Lordship, I beg to mention for listing, lordship, motion matter, lordship.
Motion matter on 6th.
6th, lordship. Developed.
Yes, yes.
May I please your lordship, I may have to mention item number 23. Senior counsel is not appearing, your lordship.
Who's senior counsel?
Ananja,
He's what?
he is unable due to some unavoidable circumstances, he could not appear. Your lordship.
All right, 23 passed over for the day. Friday. Based on Friday. On the request made on behalf of Mr. Ananja. Yes.
Your Lordship, I beg to ask for an impleadment to be brought on record with the writ petition that we had filed, Your Lordship, previously. And be brought on 4th when the case is also listed.
Have you filed your IA?
Yes, Your Lordship, we have.
Okay. So let the IA be listed on when is the matter of writ petition fixed?
On 4th, Your Lordship.
4th. Okay. Have you given the number of the IA?
Yes, Your Lordship.
In the mention memo?
Yes, Your Lordship, and the writ petition as well.
All right. 4th.
Much
I
obliged.
pay for listing of a fresh writ petition tomorrow, lordship. It is an eviction matter, lordship.
Not tomorrow. On 4th.
It is scheduled, the eviction is scheduled today, but on oral assurance, they have promised to do it on 4th, lordship.
So when did you receive the notice?
1st of January, lordship.
Mhm.
Thereafter, 15 days time was, there is an
Whatever-
earlier
whatever
order.
it is, you can't just throttle the system and say that no, it's getting evicted tomorrow. You are aware of the system.
No, lordship, there is an earlier order that the eviction should not be carried out without a proper verification of the whether it is revenue land or forest
But
land.
we can't give you unlisted tomorrow. If you want, you can take it today.
Today, lordship.
Okay.
Okay.
Bring it.
Then
Bring it
yes, yes. Much obliged.
before the bench rises.
I please your lordship. Lordship, in this case, impleadment petition was filed and it was allowed by the Honorable Court
Right.
for impleading as private respondent.
So we'll issue notice.
Notice may kindly.
Yes. Heard learned counsel for parties issued notice letter number 4 which MSM Bormon learned government advocate appears and
3, 4, and 5.
notices on behalf of respondents 3, 4, and 5. MSG Hazarika for respondent 1 and 2. Is it?
2 only.
Huh? Who's for 1? Huh? Which department is this? Respondent 1 is what department? Right, public service? Is there a department like that? Is there a department?
No, lordship. There is
Can't
no
be
department.
Disaster management, it will come.
No, number 1.
Revenue and disaster.
Number 1.
My lord, it will be revenue and disaster.
Then you will have to make the correction. No?
My lord, may allow to correct you. Lord.
What is this?
That have to correct, Lordship. This is
You will have to correct it
Right.
properly.
Service Act.
There is an act, man. There
Yes,
is an
and-
act, 2012.
Correct, but this act, who is the which is the implementing department? If there is a
Revenue and disaster management.
revenue and disaster, you make necessary application,
Correction is necessary.
corrections. Respondent number 1 and 2, G Hazarika, number 3 and 4,
3, 4, 5.
3, 4, 5, MS M Borman. And number 6, no, sorry, so notices are waived in respect of respondents 1 to 5. As the council appear, however, extra copies be furnished. Steps on respondent 6 by registered post AD as well as registered post. Dusty is also permitted. So the respondent 1 ought to have been Commissioner and Secretary to the Government of Assam, Revenue and Disaster Management Department.
That should be additional chief secretary.
Additional
Chief
Chief
secretary, commissioner secretary post is no longer.
It should have been additional Chief Secretary, Department of Revenue and Disaster Management. However, the same has not been correctly shown in the array of parties. Petitioner is permitted to make necessary corrections by filing an additional amended course title before the registry within 3 working days. Let the respondents complete instructions and thereafter affidavit, if so advised, can be filed, may be filed. You file it within 3 working days.
Smile.
Detail.
Obliged.
Detail.
Yeah, please, your lordship.
Additional
Affidavit has been filed, your lordship.
is not available here.
You have filed long ago, your lordship.
I don't know, it was not here.
So that may be.
In deference to the earlier order dated 5/1/2026, petitioner counsel submits that she has filed the additional affidavit. The same, when did you file it? But the same, however, is not on record.
January.
Please.
The 1st of January, your lordship.
1st of January.
First week of January, your lordship.
Huh?
First week of January, your lordship, as written in the affidavit, your lordship. No.
The registry is to verify and trace out the affidavit stated to be filed, additional affidavit stated to be filed by the petitioner. and
Name of finance
Connect it
department.
to the case record. Yes?
Name of finance department may be shown because respondent 1 is represented by finance department maybe. Others are LIC, no government advocate. Government department is too.
Finance is not shown.
Not shown, madam.
Registry will
But in first title it
reflect
is.
the name of the
Government
council for the finance department.
Much obliged, lordship.
Happy Riban idea.
Lordship, my instruction says that the survey has been conducted in the month of April and the report is still awaited, Lordship. And for the Union of India, Lordship. It is conducted by the DEO Guwahati, Assistant Settlement Officer, Local Military Authority in the month of April 2025. So the report is awaited, Lordship. Whether their lands are. in
When
that-
are you likely to get the report?
Lordship, that's a state government, Lordship.
We'll have to issue notice then.
Lordship.
Third, Leonard County to copies we should notice written in 4 weeks. Steps, Mr. S.S. Roy appears on behalf of. You are
4
for?
to 8.
Huh?
4 to 8, Lordship.
4 to 8. And MSG Hazarika for respondent number 1. MSM Borman for respondent 2 and 3. Since the respondents are represented, notices of the extra copies will be furnished within a period of 1 week, 20 days. List returnable date.
Obliged.
May I please, Lordship?
Where is the agreement?
What item? This is different. This is 5. You are for 5, this is 5. This is 5. It is -5, -5.
Yes,
May I please your lordship? This is an application under section 11 of the Arbitration and Conciliation Act, your lordship.
where is the agreement?
Agreement is that page 17, your lordship. It was a tripartite agreement, your lordship, between the petitioner and the respondents.
Hmm.
And at page 22, your lordship will find the clause number 3D, wherein dispute resolution has been sought, has been mentioned, your lordship, that any dispute arises between the parties will be resolved by the arbitrator, your lordship.
Mutual discussion.
Mutual discussions, yes, huh? We have sent a notice, your lordship, to the, upon the respondent number 1.
Our learned counsel would notice, you should notice returnable for with steps on respondent by registered post within 1 week from today. List after returnable date.
Oh, right.
May I please proceed? Lordship, the petitioners are the owner and possessor of the plot covered by tag number 555, 556, 557, Lordship. Lordship, under the circle of his business Iran, and they have been residing on that plot more than 50 years, Your Honor, Lordship. These floors, this property are hereditary property of their forefather, Lordship. Lordship, which has been distributed among their sibling mutually, Lordship. About 30 years ago, the respondent family shifted to this present place to be a neighbor of this petitioner, Lordship. And petitioner's father, they have no any road to go to their home. And petitioner's father on goodwill allowed the respondent to use a portion of the land covered by tag number 555 to use as their passageway, Lordship. All were going well, Lordship. Last year, suddenly, Lordship, respondents demanded a wide road from the petitioner, and petitioner refused to give the road. As a result, the respondent number 7 filed a complaint before the circle officer, requesting that there was an old road beside tag number 555 and
Where is
parcel
your
number 102,
representation?
Lordship.
Where is your representation?
Lordship,
Where is your representation?
representation, that is business circle, Lordship.
Page number.
Page number, that is Lordship. Annexer 1, that is Lordship, Sita copy, page number 24.
No, you said you filed a representation. Did you file a representation? No.
Lordship, no, Lordship. Thing is that according to the complaint, the circle Lat Mondal submitted a report, and as per report, the circle officer, along with some police officer, evicted my residence, Lordship. This is my submission.
So what orders do you want from the court?
Lordship, for denial of Lordship, illegal disposition of the court of the plot, my plot, measuring 1 katha 1 lesa covered by tag number 555, Lordship. And Lordship, denial of lawful demarcation of plot of land covered by tag number.
To whom? Whom do you want the direction to be issued?
To the circle officer by
Circle officer.
by the
Why don't
honorable.
you go and file an appeal before the DC?
DC, I have made party, Lordship.
You have made party, but why have you not gone to the DC? Go and approach the DC tell them that you have been wrongfully evicted.
Lordship already evicted my residence.
And
Lordship.
that's right, but it will have to be found out. There will have to be a measure.
We have applied application, Lordship, to the circle officer not to evict my residence, Lordship.
So where is that petition?
The application is, Lordship.
Is 37 annexure 6.
Yes, Lordship.
He has approached short application regarding demarcation of 5/5. That is
38,
25.
38, 39, Lordship. 38, 39.
There is no 39,
No.
38 only.
39 in my petition.
There is no 39.
Let me see.
37 is the type copy of 38, my lord, annexure 6.
Yes, 38. 39, that is the vernacular.
Huh.
Can you get instructions to find out what has happened?
Lordship.
Lordship, Mondolo report also annexed here. And the complaint application also in page number 35. Complaint was, it is complaint that the road,
There is no indication that it was received in the office. Is it received in the office of the circle officer?
Lordship,
37 and 38 page schedule is slightly different, my lord. So far as I have gone through, my lord, DAG number, patta number doesn't tally. I
yes,
suppose.
yes,
But-
yes, that number, but that number is not
What is the
missing.
status of these applications? That
My-
you find, get instructions.
Because whether they have filed it actually or not, that
They
is
may have
also.
filed it because there is some endorsement of the circle
In
officer.
There
my
is-
page
there is-
37, there is no such information.
36.
Lordship, in the Mondol report, Lordship, there is no similarity of the number, patta number, Lordship.
Inspection for a-
Third council for parties.
And we
Mr. M. Burman has
applied many
government
times certified
will
copy,
take
Lordship,
instructions
but
on
they
the
refuse
status
to
of
give us the
the
certified.
representation filed before the circle officer, Bijuni Revenue Circle by the respondents in respect of demarcation of the land referred to in this schedule.
36, no schedule is there, my lord. In 37, there is a schedule.
If you want, in respect of the representation filed by the petitioner. Although notices are not issued, extra copy of the written
Lordship,
petition be furnished
demarcation as well as illegal eviction, Lordship.
to the government advocate be furnished within 3 working days to enable her to obtain the required instructions. List this matter on 27th of February. You give her extra copy.
Okay, Lordship.
Yes.
Lordship, can you give a direction?
No, first let her
what-
get instructions, then we'll find out. You do not know what has happened to your land, what has happened to your application. You want all problems to be sorted out by the High Court.
Lordship, I know, but I have applied certified copy. They refuse to give me the certified copy. That
You
is,
did not say that.
and even we have applied RTI also.
Therefore, we have asked the government advocate to obtain the instructions.
Obliged, Lordship.
Fixed
Yes,
on 27th.
yes, yes, obliged. Obliged.
I can see.
May please, Lordship.
Uh,
On complaints of order dated 13/3/2025, Lordship. The
What was the
directive was to the
directive?
respondents to consider by representation. We have filed the application on 23/2025, but till date they have not taken any.
Right.
detail.
Learned, Dr. A. Todi, Learned Counsel for the Petitioner, issue notice returnable 4 weeks. Steps on respondent by registered post within 1 week from today.
Much obliged.
7.
Instructions were short as regards to the.
Lordship, instruction is waited, let it be on Friday, my lord. I'll try my best to have some instruction. This Friday, my lord. I'll make it try.
Friday.
I'll make it try.
Or we have it on 9.
Lordship, yes, please.
9.
Okay.
Uh,
But my name may be reflected in the cause, it is not reflected.
uh, What is your name?
SS Ahmed, man. It's not there in the court.
Petitioner side. Nine.
Ms. M. Bourbon, learned government advocate, prays for further time to complete her instructions. She submitted the matter be listed on leave.
9.
Mr. S.S. Ahmed, the council appeals for the petition. Registry to reflect the names of all councils in the process.
Publish.
Publish.
Piece of material. None appears.
Maybe.
Yes.
My lord, this application, my lord, is regarding non-handling over the Zim, cis Ericanats in terms of the Zima order, my lord. Consequently, my lord, this application representation has been filed seeking compensation, my lord. At this case, my lord, notice may go, my lord.
Where is that Zimma order?
Lordship will find the Zima order at page 235, my lord. Annexer U and U1, my lord. Operating part, my lord, will find at page 239, my lord.
Why have you not brought it to the notice of the JMFC that
Yes,
his
sir.
order has not been complied with? There is a
That
direction
is-
for
that
filing
is
a
the
compliance
proper way.
report.
My lord,
What happened on 7/4?
my lord, later on, my lord, we came to know, my lord, that report has been submitted saying that no, Zima could not be handed over.
So where is the report?
My lord, that report is not here, my lord.
Then why it
Now-
could not be handed over?
Now, my lord, Lordship may kindly see one annexer, my lord. Page 254, my lord. That was subsequent, my lord. When
So
the
where is the
representation-
report that it could not be handed over? What is the reason for not handing it over?
My lord, already damaged, my lord.
You know. Are you aware of the report? Yes or no?
Report to I have to place it, my lord. Yes.
Then why have you come and asking for directions? You have been asked to be given the Zimma. You take the Zimma. It doesn't say that Zimma of only fresh Erica nuts are to be given. It says Erica nuts which are sealed, damaged or otherwise, you take the Zimma. You place the report,
Yes, ma'am.
bring it on record by affidavit.
All right.
2 weeks. List the matter after 2 weeks, enabling Mr. Murray, Leonard Counsel for the petitioner, to bring on record the addition, the report submitted by the OC Delay, OC Delay Police Station as to why the Zimma of the seized Erica nuts would not be handed over. In terms of the order dated so and so passed by the JMFC, Bokajan.
Yes, madam.
Bokajan. List again after 2 weeks.
My lord, this is the report, my lord.
Huh?
This is the report.
You said it is not there.
No, it's not annexed here, lords.
You
It is
get
with
it
you.
and you bring it here.
All right.
By benefit.
Bring it by way of an affidavit.
All right, I'll bring it through it.
Besides the court going through the report, the respondent counsel is also required to go through the report. How will he go through?
Yes.
This is as per the High Court rules.
My lord,
Whatever you file,
yes,
copies must be served on the other side.
this Zimma order was granted actually in terms of this honorable court order, my lord.
So that's okay, but why the report could not be annexed? It reflects why the Zimma could not be handed over, isn't it?
Yes.
So bring it on record.
Applies, my lord.
May I please, Lordship?
Hmm.
I have filed an application for mutation by right of inheritance, my lord.
What has happened?
Legal here, my lord.
What has happened after that?
My lord, the petitioner across to the concerned circle officer as well as my lord Lad Mandal, but they have not,
How have you approached?
after filing, my lord,
Where is the application file?
my lord. An exam, my lord, 3, my lord, page 60, my lord. I filed 1/9/2025, my lord.
Mr. Sharma, what is the status again? You'll have to find out.
Lordship.
Annexure 16.
Lordship,
Page 16.
Lordship, I'll get the instruction.
Counsel for the State Council, Mr. H. Sharma, will obtain instructions on the status of the application filed for mutation of their names by way of inheritance by the petitioners. Pursuant to the application file, acknowledgement of which is enclosed as Annexure 3 in the writ petition. Mr. So and so, a case of the writ petition. Yes.
After 2 weeks, Lord.
After 2 weeks. 11.
May I please, your lordship? The petitioner is the owner of the scheduled land, your lordship. A part of land is showing in the name of government has, my lord, with a remark that it has in the name of ASTC, my lord. So petitioner has submitted a representation for cancellation. Page number 18 is the representation. Page number 18, my lord. This is the representation, my lord. After that, my lord, though my lord, the circle officer has submitted an inquiry report and hearing, but it was not finally disposed of. The land was neither acquired or not any notice was given to petitioner. So, my lord.
Again, instructions.
Lordship.
Mr. H. Sharma, learned government advocate, will obtain instruction with regard to the applications, representations by the petitioner before the deputy commissioner Sonitpur case book, which is enclosed as Annexure 3 and 4 for that petition. Let this instruction be placed before the court within 2 weeks in his SSVR appears for the writ petitioner placed again on 20 February.
Okay.
You are appearing for someone?
Respondent number 5, lordship.
HCC. MS?
K. Borpujari on behalf of H. Homa, lordship.
On behalf of K. Borpujari, on behalf of S. Somoa, H. Somoa, on behalf of respondent number
5, lordship.
5, MS PR Monto for 1 and 2.
Obliged.
I think well. Yes, what has happened? You are supposed to get some instructions,
Lordship,
not available.
our no lordship, our file is misplaced in our office, lordship. I mean, that is the problem, lordship. May I get a make a photocopy, lordship, thereafter, lordship?
He'll give you one copy. Give him one copy. Then when
Misplaced somewhere, lordship. I will
when
get-
can we get the instruction?
Next week, Monday or Tuesday, lordship. এই আপনার জৈন মন্দিরের হেতু না লর্ডশিপ লর্ডশিপ may fix it on Wednesday or Friday, lordship. I can get it, lordship, by
6th.
lordship.
Matter we listed on 6th of February, enabling Mr. H. Sharma, learned additional senior government advocate, further time to complete his instructions.
My lord, in the meantime, interim protection may be extended.
Mr. A.K. Jain appears for the petitioner. Interim order passed earlier will continue.
No more.
Interim order as per para 6 of the earlier order will continue till the next day fixed.
Lordship, lordship. I will get it.
My lord, petitioners are allottees, my lord. So, my lord, after that allotment, my lord, we have also applied for settlement of the land. So after that, what happened, my lord? Now the authority want to evict us, my lord.
Where is the allotment?
Allotment order, my lord, I have annexed. Your lordship, it is starts from page 19. Page 15, my lord. Page 15 onwards, my lord. There are some conditions, my lord, page 16. We have not violated any condition. And nothing has been said for that also, my lord. So, my lord, after allotment, your lordship would be pleased to
Yes.
turn to page 44, my lord.
Yes.
My lord, we applied, my lord, as your lordship, there is a notification, 11/11/2021 by the government that a landed person can apply it online. And we applied online, my lord. These are the acknowledgement, my lord. So those petitions are also pending, my lord. It was of 24. Now, my lord, they want to evict us from the scheduled land during that pendency of the petition. And on the other hand, my lord, as we are landlord, so allotment was made in our favor.
Mr.
My
Das?
lord, it wasn't, their allegation is of, my lord, 6/5/2005. Now is 26, my lord. They are saying this land has been allotted to them. Again, they file application on 21 saying they are landless, my lord. 25, they are sitting idle, my lord. 2005, now is 2026. New land policy has already come, my lord, 2019.
No, but these lands were allotted.
Allotted, my lord.
2005, my lord.
Or
But
maybe.
Yes.
allotted, if your lordship come to the page 28 for the time being, my lord.
28. Yes.
Number 8, my lord. This certificate cannot be considered as an annual patta nor any other type of patta as stated in Assam Land and Revolution Act.
That is okay.
My lord, premium have to be given.
Huh?
Not premium also have to be deposited, my lord.
Which they have. They
Well,
deposited.
From 2005 to 2026, they've been saying they've been allotted. Again, they applied on 2021 in new land policy of 2019, my lord.
Where is the allotment? Second allotment? Second application?
The whom page it, sir?
My lord, second application, my lord, that acknowledgement, my lord. acknowledgement received, it is of 20.
So why did you apply for the second time?
No, my lord, because my lord, it is an allotment to us. It is not settlement. Allotment for a.
No, no,
particular purpose.
you read the first line of your acknowledgement.
Yes, my lord.
Read the first line. It is an application for allotment certificate to periodic patta. You have already been given an allotment certificate.
No, my lord, allotment is another, my lord, your lordship referred to
Page number 47.
47. Lord, this is not the application, my lord. This is not application for allotment. It is an application for settlement, my lord.
You were allotted some land.
Yes, my lord.
Subsequently, you again made an application.
My lord.
For what? For what?
My lord, this language, my lord, this language is not proper.
We
We
are
have applied for patta, man.
patta land.
Yes, my lord.
So,
We have applied for patta, but it
This
is written
47
that your application for allotment certificate
uh,
to periodic patta.
uh,
Allotment to be converted to periodic patta. There may be some confusion in the office level, my lord. But we applied, my lord. We applied for periodic patta.
If your lordship allow me, I can submit one more thing, my lord.
Hmm.
Page 47. If the application has been accepted by the Revenue and Disaster Management Department, the service shall be provided within 90 days. You may raise an appeal at this if the service is not delivered within 90 days. Or you can call. This application is of 2024, 26/11/2024. Now, my lord, this is 26. Beyond 90 days. And appeal also lies, my lord.
what happened? No appeal.
Nothing
lord,
fine,
I
my
did
lord,
not
after.
prefer appeal.
Huh?
Did not prefer appeal, my lord.
Why?
Because, my lord, we are in the hope that our application has been accepted.
Can't be-
And application has been accepted and we are allottees,
Now,
they
what-
will do the notification.
What orders you want from the court now?
My lord,
What orders you want from the court?
they should not be evicted without disposing
No,
of the
they should not be
applications.
evicted. It can't be a blanket order.
My lord, no, my lord, when our application,
Your claim is that you were allotted some land. After that, you had approached for settlement.
Hmm.
Nothing happened.
nothing
Now
happened.
they are trying to evict you. That is
My-
your case?
My lord,
Now, in terms of the application for allotment, where the acknowledgement is given, it's a
Hello.
very clear indication that it is to be provided within 90 days, and if you don't, then file an appeal.
my lord.
You did not file an appeal. You
Appeal
did not pursue the matter.
Appeal did not file, my lord. Appeal did not file. My lord, my humble submission before your lordship. We have not filed the appeal. Statutory appeal provision is there.
Hmm.
But thing is this, my lord, whether the authority can evict us now
Why not?
without
We'll follow,
acknowledgement,
my lord. We'll follow Sarakuddin, my lord.
without, my lord.
We'll follow due procedure of law, my lord. We'll
My
follow.
lord,
sir.
my lord.
No notice.
Your lordship will consider. Supposing-
You come back to your allotment certificate.
Yes,
The
ma'am.
conditions.
Yes,
Condition number,
15,
page number 28 or?
15, my lord. I am going to 15.
All right, 15. Come back to 15 or 16.
Yes, my lord.
You see the conditions.
Yes,
Number 7, if you're not if you're considered ineligible.
7.
7.
If you are considered ineligible for allotment of land, you must hand over the possession of the allotted land.
Hmm.
But if you are considered ineligible, is there any finding on the part of the authority? My humble submission before your lordship, no finding. Our allotment is not cancelled. Whether without cancelling our allotment.
That you should have filed an appeal.
Well, yes,
It is
your
a matter
lordship,
of- It requires examination of facts.
my lord,
Your claim versus the claim of the department.
my lord,
You should have filed an appeal before the appellate authorities.
my lord,
You did nothing.
my lord.
You sat over it. There is no explanation why you have not filed an appeal.
My lord, my humble submission.
And
before
no
your
explanation
lordship,
also why, my lord.
allotment is given to us. Allotment is given as
Then
that.
go and file a suit.
I have not,
Go and file a suit
My
You
lord.
want a right title declaration to a right and title, go and file a suit.
My lord. No, my lord, in that case, my lord, as your lordship pointed out that there is a appeal provision. I will go for appeal, my
You
lord.
file appeal.
My lord.
Who's stopping you? Maybe you have to withdraw the petition.
My lord, no, my lord, only I am not withdrawing, but your lordship with that observation that I have option for appeal, petitioner may go for
Right.
appeal.
With that
Appeal, my lord.
That appeal is to be filed within 90 days.
My lord.
Whether now they will accept your appeal or not, we
Well,
don't know.
that is another thing. If they do not accept it, that may be mentioned by your lordship.
No.
My lord.
Why? Why should we bend the rules for you?
Well, in that case, my lord, my humble submission before your lordship, that appeal provision is there. Our acknowledgement is there, my lord. They received our application. They did not dispose of within 90 days. We should have go to the appeal, but it is not the thing that without disposing our representation, without cancelling our allotment, will be evicted.
Don't know that. If appeal is not maintainable, you won't file a suit.
My lord.
Third counsel for party, the petitioners before the court claim to be landless person who were allotted land by the government by allotment letters. When were you allotted land?
6/5/2025, to 2005.
Where is that?
My
Page
lord,
number?
page,
It says 2020 only.
no, my lord, 6/5/2005. I'll show it, my lord. I'm saying from the vernacular document itself, my lord.
Page 25, ma'am.
20, my lord.
My
Page 70.
25 also is there, my lord.
No,
My lord, your lordship,
come to page number
17, my lord.
17.
19/12/2020.
No, my lord, page number?
9/17.
Were allotted lands on various dates as far back as 2004. Up to
There are-
2020. Stop.
No, but
The allotments made to the petitioners, they're subject to a set of conditions which are reflected in the allotment certificate.
এইটো পাছত দিছে, এইটো হাতত দিছে।
And they were also required to pay the revenue regularly. So petitioners claim that they have paid their revenues regularly. So thereafter, by an application made in the year 2015, the petitioners made application for conversion of their allotment certificates to periodic patta. Stop. The petitioners submit that their applications were accepted and acknowledgements were issued, which are enclosed as Annexure 4 series and 4A, capital A. Stop. The counsel for the petitioner submits that thereafter no response has been received from the petitioner and from the respondents, and now they're sought to be evicted from the land which they were earlier allotted. Being agreed, the present writ petition has been filed. Thereafter, from the acknowledgement issued for the applications filed for conversion of allotment certificate to periodic patta, it is seen that the said acknowledgement clearly mentions that if the application is accepted by the Revenue and Disaster Management Department, the service must be provided within 90 days. And if the service is not provided within 90 days, the applicant can apply at the website preferred or emails for complaints and also at the toll-free number prescribed. Stop. Where are the petitioners, however, have no explanation why after 90 days they did not pursue their claims before the Revenue and Disaster Management. Stop. This the learned counsel for the petitioner has also not been able to explain in the absence of any specific instructions as to why the petitioners did not pursue their claims in terms of the claims in by filing necessary applications in the web portal as prescribed or mentioned in the acknowledgement furnished by the Revenue Department. Stop. Is there any notice for eviction?
No,
No,
my
my lord.
No notice for eviction has also been issued to the petitioner. And this writ petition has been filed purely on apprehension expressed, which according to the court is not supported by any cogent reasons or basis. Stop. Under such circumstances, this court is not inclined to issue any notice or directions to the respondents, save and except grant a liberty to the petitioner to approach the Revenue and Disaster Management by filing necessary applications at the web portal and the email mentioned in the copies of the allotment, copies of the acknowledgements issued to the petitioners. In the event the petitioners' grievances are not redressed, it will be open for the petitioners to approach competent court of civil jurisdiction to have their right, title, and interest decided, if so advised.
My lord, those application, if would be filed, will be considered as per law, my lord. That line, if possible, my lord.
It has to be as per law. As per law.
My lord, one thing, my lord, regarding this acknowledgement, my lord, date is 24/11/2020.
We have mentioned the
Application.
annexure numbers.
My lord, annexure number, my lord, 40, annexure number 4C. That is dated, my lord, 26/11/2024. It should be
26/11/24.
24.
Acknowledgement dated.
2024.
Oh.
Obligation.
If possible, my lord. As- If possible, my lord.
What is possible?
As per law, my lord. That like,
Why do you want that as per law? Everything has to be done as
Well,
per law.
otherwise they will think the petition has been allowed, it will have to be considered, my lord.
It is not
If-
allowed. We have made it clear that we are not inclined to issue notice or direction. We have made it absolutely clear. Other than dismissing it, we are just making it pleasing to the petitioners, sending them back to the department. If you want to file, you file. Yes?
All right.
May I please, Your Lordship? Lordship, in this case, petitioner was read by the accused person and thereafter petitioner submitted two representation before the respondent number 3 and 2.
Where is that? Where is the order of the trial court?
No, Lordship, that matter has been pending.
Pending.
Yes, Lordship.
Then under what provision you ask for compensation?
As per the Assam Victim Compensation Scheme
Show
2012.
us, where is it?
At page 42, if your Lordship will see the item number, serial number 3.
42,
Yes, Lordship. Serial number 3, victim
serial
compensation.
number 3.
Yes, Lordship.
Then where is the act?
The act, your Lordship, if your Lordship will find at page 37, eligibility for compensation, clause number 4, your Lordship.
Clause number 4.
Yes, Lordship.
What does it say?
Clause number 4 for your Lordship.
Uh,
Where the perpetrator of heinous crime is not traceable or go unpunished after trial, your Lordship.
So what is the status of the trial?
That has been pending for
Then?
fixed for evidence, your Lordship.
Then how do you say that your clause 4 is applicable?
Because your Lordship, if after the trial court, a case is acquittal, then the petitioner will be entitled for the, and after unpunished, then they will also be entitled for the compensation.
But
your
have the
Lordship.
trial is still pending?
Pending, your Lordship.
Then?
If your lordship permit, other than that, my lord, that is clause number 7 limitation, my lord. Page 38, my lord.
After 6 months.
Yes, my lord.
Within 6 months.
Within 6 months.
representation may be
And this is
petition.
the case of 2022, my lord.
If the, apart from that, your Lordship, if any case pending before the trial court and petitioner will not submit any application within limitation 6 months.
And it's clause 5, your Lordship.
Hmm.
5 is the, wherever a recommendation is made by the court or an application is made by any victim or his dependents under subsection 2 of so-and-so of the act, the so-and-so will look through. This is the provision by which even during the pendency of a trial, an application may be made. And if it is, if the trial court recommends any
Application to be made before DLSA.
Yes, Lordship.
Have you made it?
Yes, Lordship. We have made, we have annex also.
Page 34, my lord, that is
34 and
57.
What happens when the application is made?
Plus the victim compensation case is registered and then they are required to go and appear before the member secretary there. And their depositions are taken and evidence is recorded and thereafter an order is passed.
Where is your application?
Application
34.
at page 34, your Lordship. That has been filed on 5/7/2023.
34.
Yes, Lordship.
Before DLSA.
Yes, Lordship.
Oh. Then what has happened after that?
That has been pending.
I don't know what.
Who can get instructions here?
Lordship, both of us could get the instructions. Lordship, take it up next week and
Oh.
next Monday perhaps, we can get the instructions.
Get instructions, what has happened?
Other than that also, my lord, it is barred by.
Yeah, Lordship.
Let that be decided by the DLSA, if required.
Yes. Upon state organ, state.
Why should we put, indicate,
Well,
if the DLSA feels that it is time barred, it is, if they feel it is not, it is not.
There is a appeal provision also.
Counsel for the petitioner is agreed that the application dated 5/7/2023 filed by the petitioner before the member/secretary DLSA. Agree.
May I submit one thing, your Lordship?
Has not been taken up and appropriate orders have been passed. So who is the petitioner?
Victim himself, herself,
Victim.
herself.
Petitioner is a victim of an offense
extra copies divided.
under section 365/376 in connection with Gauripur PS case number 74/2022. Read with section 6 of POCSO. She's a minor.
At that time, minor, now she is married. Therefore, 2 application is submitted. One is by her father.
Mr. N. Das, General Government Advocate, MS R.S. Chaudhary, learned counsel appearing for Asalsa.
But yes, Lordship. So,
Will obtain instructions on the application filed by the victim petitioner, before the DLSA Dhuri. Let this instruction be placed before the court on 9th.
9th.
All the notices are not issued. Extra copies be furnished to the respective respondent counsel within the course of the day.
Yes.
Development.
Huh?
Today, Lordship,
By tomorrow.
By tomorrow.
By tomorrow. Yes.
I'm sorry.
Mhm.
Please, Lordship. The another 2 minutes, plus 10 minutes, file in application.
Again, instructions.
Yes, yes, this instruction.
Mr. N. Das, Leonard Counsel to the state will obtain instructions as to why the application for mutation of the name of the petitioner in the record of rights has not been carried out. List again on 13th. Although notices are not issued, extra copies be furnished within 2 working days.
But extremely sorry, item number 8, my lord, I was absent, my lord, because I was in another court, my lord. Item number 8.
Extra copies are ready.
Yes.
My lord, page number 16, my lord, another 3, my lord.
Same order.
Same.
Same order. 13 number.
Same number.
8.
8. I'll have it.
May it please your lordship. Lordship, this petition is filed praying for a direction upon the registrar hand date. For, my lord, this petition has been preferred, praying for a direction to be issued upon the respondent number 7, my lord, registrar hand date, Bukakhat Primary Health Center, for cancellation or correction of the date entry, my lord, of the my lord, father of the respondent number 8. My lord, before
cancellation.
Yes. My lord, before that, my lord, I just want to place the facts, my lord. My lord, the predecessor of the petitioner, my lord, he purchased a plot of land by way of deed of sale from the predecessor of interest of the respondent number 8. Way back in the year 1970, I have annexed that sale deed as Annexure 1, my lord. Annexure 1 is the sale deed.
Yes.
That was executed way back on 1970. Thereafter, my lord, we have been possessing that particular land. And, but my lord, as there was a, immediately after, my lord, our purchase, my lord, by predecessor, my lord, this land was to be acquired by the second extension of the Kaziranga National Park. So therefore, my lord, our names and as well as our predecessors' names were not recorded, my lord. And in the Jamabandi, my lord, the name of the predecessor of respondent number was remained. But in the note of the Jamabandi, it was specifically mentioned that the land was earmarked for the second extension of Kaziranga National Park. Thereafter, my lord, what had happened as the in the year, my lord, 2023, my lord, we have been offered, my lord, land compensation, my lord. Total 10 numbers of notices were issued. 4 notices were issued upon our family members, my lord, petitioner's family members. And my lord, 6 notices were issued upon the father of the respondent number 8, who had died already, my lord, who had died. So, my lord, when, my lord, we have seen that, my lord, as they were not interested person, therefore we made an application before the concerned, my lord, land acquisition authority to release the compensation amount on protest, as well as, my lord, for cancellation of the notices which were issued upon the father of the respondent number 8. And that was pending. Therefore, my lord, we have approached before the dishonorable court by filing a writ petition, my lord, that is still pending. And in that writ petition, my lord, we have made, my lord, the respondent number 8 and other family members as party. So in that writ proceeding, my lord, they have filed with an affidavit in opposition, my lord. And in that affidavit in opposition, they have enclosed the one permission, my lord, permission for delayed date registration. That your lordship will find it annexure to page 24. Well, lordship got it. This is permission for delayed date registration. It was name of applicant Khem Bahadur Chetri, that is the respondent number 8, and name of the deceased late Krishna Bahadur Chetri. And my lord, the Krishna Bahadur Chetri was that person, my lord, who sold the land to us, my lord, to the predecessor of our petitioner, my lord. And here lordship will see, my lord, the confirmed date of date 22/12/1969.
Look, it is not Krishna, it is Khem Bahadur.
No, no.
Respondent 8.
No, this is for permission for delayed date registration.
Correct.
And by that, my lord, they want to got a date certificate of late Krishna Bahadur Chetri, my lord. And their lordship will find that confirmed date of date 22/12/1969.
Where is that death certificate again?
Thereafter, my lord, death certificate was issued, my lord.
No, you pointed out to some death certificate.
My lord, what had happened, my lord? As per, my lord, section 13 of the
No, you pointed out to a certificate now, just now.
Oh, yes, yes. Annexure 2, my lord. Annexure 2. Page 24.
24.
Page 24.
Yes.
This
So
is, my
the
lord.
permission for delayed death registration.
Yes, yes, yes.
In respect of whom?
In
Krishna
respect
Bahadur.
of, my lord, late Krishna Bahadur Chetri, my lord.
Ah.
And the applicant, name of applicant, Khem Bahadur Chetri, he is the respondent number 8 of this writ petition, my lord. My lord, there your lordship will see, my lord, confirmed date of date 22/12/1969. Well, this was enclosed with the affidavit in opposition in the writ petition, my lord, which is still pending, my lord. And my lord, this shows, my lord, the permission for delay, the date of confirmed date of date is 22/12/1969. Whereas, my lord, this, my lord, the Krishna Bahadur Chetri has sold the land in the year 1970. That is on, my lord, 17/3/1970, my lord. So, my lord, in order to get that compensation money.
What is the status of that writ petition?
In
Other
that-
writ petition?
That petition, in that writ petition, my lord, they have filed their affidavit in opposition, my
That
lord.
is filed by you.
No.
Writ petition?
Writ petition was filed by me,
Praying for?
praying for cancellation of 6 notices, my lord, by way of which, my lord, land compensation offered to the person who was not at all interested person, my lord, because he is not entitled to get that compensation, my lord. So thereafter, my lord, we have, my lord, from the side of the petitioner, one RTI application was filed for getting the permission for delayed date registration. Along with that, whatever documents they have enclosed, date certificate and all. And my lord, we have, after receipt of that, my lord, all the documents, my lord. There we have find, my lord, one date certificate was issued, that will find the annexure 3, my lord.
Now you prayed for cancellation of this
Yes, yes, yes.
corrected death certificate.
Yes, yes, yes. We pray for cancellation of this, my lord. Yeah.
Then what?
So then, my lord, what had happened, my lord, we have made that application at page number 26, my lord, on 30 August 2025, before the respondent number 7, my lord. Then, my lord, the respondent number 7, after acknowledgement, my lord, may kindly see on the, just in the last line, my lord, received the copy today, so and so, and forwarded respected CDC, Madam Bokakhat, for needful. So it was forwarded to the respondent number 6, my lord. Co-district commissioner, my lord, Bokakhat. Because, my lord, that co-district commissioner issued that permission for delayed date registration. So, my lord, on that very day, my lord, we have also filed one separate application to the co-district commissioner, intimating that forwarding of that particular application, and whatever ground we have sought for, my lord, we have categorically stated in that application in the 1 to 8 of that particular, in paragraph, my lord, 1 to 8 paragraph. And we have prayed for cancel the permission for delayed date registration. And, my lord, as well, a cancellation for a permission for delayed date registration. And, my lord, pending decision of this application, keep in abeyance or suspend the permission for delayed registration. Then, my lord, may kindly see annexure 6, my lord, page 36. one hearing was conducted, my lord, by this learned CDC, my lord, respondent number 6. Page 36, my lord, this was issued upon the petitioner, and my lord, similar notice were also issued upon the respondent number 8 also. And thereafter, the learned CDC, my lord, finding that it was wrongly issued and due to oversight, it was a mistake committed on their part. So accordingly, that permission for delayed date registration was cancelled. So thereafter, my lord, and that your lordship will find Annexure 7, my lord, that will show the status, my lord. Annexure 7, service name permission for delayed date registration and status rejected. That was rejected. So thereafter, my lord, again we have opposed one separate application, Annexure 8, to addressing to the respondent number 7. And there we have made that application for cancellation of entry in the original register of date bearing so and so in respect of Krishna Bahadur Chetri. And we have categorically stated that the learned CDC who has issued that permission for delayed date registration, they have cancelled it. So so therefore, as per section 15 of that Registration of Births and Dates Act 1969, and as per Rule 11 of that Assam Registration of
Assam, Central, no.
I can give this. My lord, may kindly first see, my lord, section 13 of that, my lord, Registration of Births and Dates Act. 13, my lord, delayed registration of births and dates. 13.1, any birth or date of which information is given to the registrar after the expiry of the period specified therefore, but within 30 days of its occurrence, shall be registered on payment of such late fee as may be prescribed. 2, any birth or date of which delayed information is given to the registrar after 30 days, but within 1 year of its occurrence, shall be registered only with the written permission of the district registrar or such other authority on payment of such fee and on production of self-attested document in such form and manner as may be prescribed. 3 is important, my lord. Any birth or date of which delayed information is given to the registrar after 1 year of its occurrence shall be registered only on an order made by a district magistrate or subdivisional magistrate or by an executive magistrate authorized by the district magistrate having jurisdiction over the area where the birth or date has taken place after verifying the correctness of the birth or date and on payment of such fee as may be prescribed. So, my lord, on the basis of this 13.3, my lord, that permission for delayed date registration was issued.
Yes, 13.
Then, my lord, may kindly see section 15. It says about correction or cancellation of entry in the register of births and dates. If it is proved to the satisfaction of the registrar that any entry of a birth or date in any register kept by him under this act is erroneous in form or substance or has been fraudulently or improperly made, he may, subject to such rules and as may be made by the state government with respect to the conditions on which and the circumstances in which such entries may be corrected or cancelled, correct the error or cancel the entry by suitable entry in the margin without any alteration of the original entry, and shall sign the marginal entry and add thereto the date of the correction or cancellation. So, by way of this section 15, my lord, duty was cast upon the registrar, my lord, who issued the death certificate or birth certificate. Now, my lord, may I see the Assam rule, my lord. 11, my lord, rule 11. And it says about correction. Lordship got it? Rule 11, correction or cancellation of entry in the register of births and dates. One, if it is reported to the registrar that a clerical or formal error has been made in the register, or if such error is otherwise noticed by him, and if the register is in his possession, the registrar shall inquire into the matter, and if he is satisfied that any such error has been made, he shall correct the error by correcting or cancelling the entry as provided in section 15, and shall send an extract of the entry showing the error and how it has been corrected to the ship register of births and dates. My lord, here the relevant one is 6, my lord. Rule, sub-rule 6 is relevant, my lord. It says, my lord, if it is proved to the satisfaction of the registrar that any entry in the register of births and dates has been fraudulently or improperly made, he shall make a report giving necessary details to officer authorized by the ship register by general or special order in this behalf under section 25, and on hearing from him take necessary action in the manner. Say 7 says, in every case in which an entry is corrected or cancelled under this rule, intimation thereof should be sent to the permanent address of the person who has given information under section 8 or section 9.
Now, who's for the respondent here?
Lordship here.
Health.
Yes, Lordship. Health, Lordship, there is a representation
Ah.
where the petitioner is ventilating their grievances.
Page 39.
Yes, Lordship. Lordship, I'll just seek some time to get my instruction on this. That is, what is the stage? at
All right.
court?
Heard. Mr. M. Dr. Counsel to the Commissioner, Mr. H. Oliha, Standing Counsel Health. The petitioner is agreed that the initial delayed death registration of the late father of respondent number 8, which was issued on 18/5/2023, and on a complaint raised by the petitioner, stood subsequently cancelled on 11 November 2025 on the ground of incorrect information. The petitioner, having filed a representation before the Registrar of Birth and Death, Pokakat Primary Health Center, bringing to his notice the cancellation of the
Permission.
delayed registration of death of late Krishna Bahadur Chetri, who is the late father of the petitioner. Consequential necessary follow-up action, including correction in the Register of Birth and Death, has not been carried out by the authority concerned, as is mandated under the provisions of Registrations of Birth and Death Act 1969, read with the Assam Registration of Birth and Death Rules 1999, more particularly Rule 11.6.
Yes, Rule 11, my lord.
Rule 11. There are being agreed, the petition has been filed seeking a direction to see respondent number 7. Stop, Mr. H. Oliha, Leonard Standing Counsel Health, submits that he would like to complete his instructions. In respect of the said application, Mr. N. Das, the government advocate, represents
156.
1, 5, and 6. Mr. Choliha
2, 3,
represents
4, and 7.
2,
2, 3, 4, and 7, Lordship.
3, 4, and 7. 6 time to obtain instructions on the said application filed with the respondent Sajana. Change program. Let these instructions be placed before the court within 2 weeks. At this stage, although notice is not issued, extra copies be furnished in a period of 2 working days. Placed again on 20 February. Yes.
My lord, my lord has observed on the date of rejection of permission on 11/11/2025. That need to be correct. That is actually on 17/10/2025 instead of 11/11/2025. Because my lord, hearing was done on 17/10 on and on that very day. it was-
Where is that page number?
Page number, lordship, 36, my lord, may kindly see. Page number 36. It was hearing,
Corrected on
hearing was took place on 17/10/2025. And on that very day, my lord, that permission.
17/10/25.
Yes.
What?
Obliged.
May it be lordship, my lord. This is the case from Kironi, the previous case, my lord, here the petitions are filed. And there some antisocial elements burned out their entire residential residences and other properties, including ornaments of the women wearing apparel, etc. I have annexed the photographs at 56 page onwards. My lord, these people came from Bihar in 1970 and settled there. They are doing sugarcane cultivation. As the lordship knows, in Karbiangrong, in Kironi, Mailu area. And they have got the documents, my lord, to show. Some of the documents they could say, my lord, paying Saudi revenue since 1974, 78.
You're asking for setting aside of an order dated 2002/24.
24 months, taking that clue, we are certain to be evicted. But our land doesn't fall within PGR because our land is, our houses are surrounded by the all patta lands around that area. So others have been given settlement manner. They are also Biharis from Bihar and Gorkhas also. Some Bengalis also, Assamese also. So here there is a threat. And already, my lord, the threat has been executed in the form of, my lord, burning of the houses and properties. You also can see page 56 onwards. We have also prayed for police protection also.
No, what is your prayer now?
Prayer is, my lord, that we should be protected, my lord, so that we do not lose our life and property anymore.
That you go and file your FIRs before the authority concerned.
That we,
and you tell us that they have not been registered or taken
my
care
lord,
of.
further the eviction of the threat of eviction.
No,
should be evicted.
eviction of there is an order of 20/02/24.
Yes, sir.
You have not been evicted till now.
We are not evicted. We are there, but we have been already, houses have been destroyed, my lord, burned down totally. But we are again reoccupied there. So we are there.
Now, if this land is not allotted to you as per procedure, then you are required to vacate it. Or make necessary application before the authorities for allotment of the land.
Yes, there is the order, my lord, passed by your lordship's, my lord, in one of the 339 families, my lord. This one, it is it. And here crucial question is, my lord, whether Rule 18 would come in scheduled area. Because Mekil district land revenue act, my lord, 1959 says there shall be separate procedure for eviction. It is exactly the order passed in 339 families. In this case alone, there are 73 and 74 families. Very important. And the represent pending, my lord, in that they filed the affidavit also. There are a series of cases, my lord, pending.
Yes, Mr. Sufia, what do you say?
It's going to order.
Let's look into the order. Earlier lordship passed the order, my lord. In this particular case, my lord, Lordship has already disposed of that particular petition, directing the petitioner to approach the, my lord, assistant revenue officer submitting the individual application, my lord. That whether they are residing there along with their relevant documents, my lord. And in this case,
do you have an extra copy to be shown, Mr. Sharma?
एके order, Punjit order, Devas's order, Devas's order, एके order. And admittedly, they are coming in 1970 and our act is of 1953, my lord. Whether they are residing in the PGR land, my lord, they have to submit the application furnishing along with the documents to prove that they are residing there since 1970 or have their rights on land, my lord. And lordship has disposed of the petition with a direction to them to approach the assistant revenue officer submitting the documents and along with the relevant documents and application. And till then, my lord, lordship has deposited.
Have you gone through the order?
No, my lord, I haven't gone.
Go through the order. This order. This order was passed on 21/1/26.
Protection is application certificates.
This will take care of your
Grievances,
grievances.
my lord.
Only that, my lord, since our houses and everything is gone, some may have documents, some may not have them. Those available, I have annexed.
Huh?
Those documents available, I have annexed.
Hmm.
Otherwise, everything is gone.
No, but
Yeah.
then,
Anyway, we will make application, my lord. Whosoever has got the document, my lord, a lordship order will stand. Individual will apply for settlement
all right.
or allotment.
Then we are closing it in terms of this order.
But
My lord,
We are disposing it off in terms of this order.
yes, only my lord, the document part.
so whatever the relevant document with them, my lord.
have-
What are
you
available?
furnish
with
it,
you? Whatever
whatever
is available with you.
No, no, if you have some documents issued by the authorities, the copies are destroyed.
They
Yes,
You
cannot
can
the
still have
certificate.
you can still apply for certified copy. Mr. R.P. Sharma, Ladakh City Council, assisted by his so-and-so, Edeka, the Mr. J. Chuchgan, under standing council, Karbi Anglong Autonomous District Autonomous Council, and Mr. N. Das for
3568.
3568. MSPR Monto for 1. Mr. Sutia appears for all.
No, my lord, my lord, 2, 3, 4,
2, 4,
and 7.
2, 4, 7.
And they have to submit the application to the respondent number 7. Earlier, it was 6.
All right.
You will say no.
They do same order for you.
Revenue officer should submit full, it's a diversity disposal of police.
Get a para number 2 because they are a person belonging to Gorkha community. Here you will write para 3 does originally hailing from Bihar. Para 3 of the writ petition will stand replaced in this para 2. And
Now, one submission may be noted, my lord, that we are not in the PGR land.
the petitioner will submit their application instead of respondent 6 in the order, it will be respondent 7. At a line the petitioners claim that they are not residing on any PGR/PGR land. Yes.
If they are acquiring, we say we are not in PGR.
Yes, we recorded.
I'm one more thing, last line you have lost my candidate, that in case we are agree by it, we may approve to. In case we are agree with the order passed by them, then there will be liberty to approve.
Needless to say that.
That is there, but about the
Needless to say that.
little clients, my lord, they would.
How you have to convince them, you have to use
Yes, sir, we do convince, my lord, but they are totally illiterate.
Needless to say that in the event the petitioners are aggrieved by orders passed by the authorities as directed, they will be at liberty to approach the state court. They'll be at liberty to approach appropriate forum.
Yes.
For redressal of their grievances.
Yes.
Yes. Yes. order to sign over, petition to sign.
Supplementary list, no most of items 30.
Any instructions?
My lord, I have instructions. I can. Well, the area which you claim, my lord, it comes within the forest, my lord. There is a survey to that effect. I'm handing over the report along with the survey report. Yes. Don't know.
It is within the forest area.
Actually, Mr. A.R. Bhaiya, he is not well today.
Huh?
Mr. A.R. Bhaiya, he is not well today. That's why he couldn't appear before this court box.
If he is not well today, then what to do?
Lord, could kindly adjourn this matter for today.
For today? Then let it be on Wednesday.
Wednesday.
Mr. D. Gogoi, learned government advocate.
Well, standing counsel,
Standing
my lord.
Council Forest has placed his instruction before the court. According to the said instructions, the land claimed to be under the possession of the petitioners are within the forest area, as the same was revealed from a joint survey conducted by the Forest and the Revenue Department, Stockton. MS so-and-so, learned counsel representing petitioner admits that the Mr. A.R. Bhaiya, counsel for the petitioner, is indisposed, therefore seeks accommodation for the date. In view of the prayer made, list this matter on fourth. When is
Nothing one.
The second round of litigation for this petitioner, your lordship, 10 in numbers, your lordship. They are resident of your lordship, forest villages, your lordship, NS Solmora and Old Solmona in Sribhumi district, your lordship. In fact, your lordship, page 20, your lordship will find, your lordship, these are certificate issued by the authorities, your lordship. And ultimately, your lordship, an eviction process was initiated against them. And if your lordship kindly come to page 34, annexure 2.
Yes.
Some of the petitioners in the present case, your lordship, referred the writ petition, your lordship. And that has been disposed of by this honorable court. Operative part starts from page 36, your lordship. After recording everything, your lordship will kindly come to para 6, page 38. Last part of the direction.
What was the consensus arrived at?
That your lordship, next line your lordship will find, it is further observed that any further eviction to be carried will be subject to the outcome of decision only pending writ petition so and so. That issue was, your lordship, whether heritable right will be there or not for the, your lordship, in respect of the
So
land.
this is in respect of certain parcels of land.
Lordship.
Where the forest department said that they will not carry out eviction.
Lordship. That's who we are in the occupation, your lordship, and we.
It is this land that you are in occupation.
Yes, your lordship.
All right. Then
your lordship, next order page 39, your lordship. Some of the petitioners, your lordship, have come up with this petition, your lordship, and here your lordship will find page 44.
You were directed to file representation before DFO.
Yes, Your Lordship. Now your lordship will kindly come to page 46, para 7. Taking note of the projection made in this petitions that the petitioner residing within forest area for more than 75 years of tree generation as provided under section 2 of the Scheduled Tribe and other traditional forest Act
So
2006.
thereafter you filed.
We filed, your lord. That's your lordship will get it at page 47.
Then what happened?
Then your lordship, what order they have passed, we are not aware, your lordship. And ultimately, again, your lordship, in respect of these petitioners, your lordship, notices were issued, lordship. Notices for eviction, your lordship will get those notices at page 58.
Mr. Goswami, any orders passed by the DFO?
He could not because they have never submitted this representation.
That your
By
lordship,
specific instruction, my lord, no representations filed. Even this representation they have annexed, my lord, but doesn't contain any seal or signature of receipt, my lord.
lordship, so far as your lordship, we are concerned, your lordship. These are the along with the documents, your lordship, we have at page 57, your lordship will kindly see those documents.
No, but the representation has not been served, that's what.
No, your lordship, we have made a specific averment that we have submitted this representation. Your lordship.
Now, how do we?
Now, your lordship, what happens in many cases, your lordship, they don't, your lordship acknowledge the receipt, and your lordship, these are your lordship.
Then you are aware of how.
I am definitely aware, but your lordship, in some cases, these people, your lordship.
But then how will the court now come to a conclusion as to who is giving the correct picture?
Lordship, then to that extent, then they will have to come up with an affidavit that this representative.
But the affidavit is okay, but.
But your lordship will kindly see.
That affidavit does not mean that your eviction notices or process will be not undertaken.
Lordship. And in fact, your lordship, we have made a specific.
Mr. Goswami,
My lord.
assuming that they did not serve, you did not receive.
Yes, sir. They can see.
They have enclosed this.
My lord.
Can you get instructions as to whether any?
I have detailed instructions, my lord. They can still file a representation, my lord, if I submit my representation, any instructions, my lord. Before that, I'd request your lordship to peruse the earlier two orders, my lord. Just to identify the petitioner. If we, my lord, take up the cause title, I have already.
Cause title of?
The writ petition, my lord.
This writ petition.
This writ petition. There are two writ petitions filed. There were two writ petitions filed. My lord will kindly take note, my lord. Petitioner number 1, 2, 3. Petition number 1, 2, and 3, my lord, were party in writ petition number 946 of 23. This is relevant, my lord. 1, 2, and 3, 946 of 2023. That then, my lord, petitioner number 4 to 9 are, my lord, petitioners in earlier writ petition 2540 of 23. 8 and 9 are, my lord, wife and son. So, but still, my lord, their interests were common in that writ petition 2540 of 23.
2540
of 23.
Second writ petition.
The first writ petition, my lord, there 1, 2, 3. Second writ petition 4 to 9. 10, my lord, is nowhere to be found. Suddenly he has joined this writ petition without any document also. And if we, my lord, see the writ petition, first writ petition, my lord, page 32. 34, my lord, annexure 2. These three petitioners were, my lord, petitioner number 4, 5, and 7. 4, 5, 6, and 7 in 4, 5. Sorry, my lord, 4, 6, and 7 in this writ petition. The first three of the present writ petition. Anyway, my lord, if we now see, my lord, the order, my lord, they all along contended that they are residents of Solamona Forest Village and they are wrongly getting evicted. So, paragraph 4, my lord, will kindly see the writ petition, my lord, page 37. Paragraph 4, my lord. Page 37. Mr. So-and-so, learned counsel for the petitioners has submitted that as successor in interest of the petitioners who were allocated land inside NS Solamona Forest Village under Longoi Forest Reserve, petitioners have a right to continue in such allocated land. Mr. Longoi, learned so-and-so, has however raised an issue regarding absence of any hereditary right to the petitioners to continue as forest villagers in the lands allocated in the names of the petitioner's predecessors in interest. It is submitted by him that the said subject issue is a subject matter of the writ petition in WPC 4775, which is pending as on date. My lord, may kindly take note of this writ petition 4775. My lord, let us skip to the last portion of the order, my lord. Paragraph 6, next page, my lord. Having considered the submissions of the learned counsel for the parties, this court is of the considered view that there is no necessity to keep the writ petition pending in view of the broad consensus arrived at by the learned counsel for the parties. In the manner noted above, the writ petition is accordingly disposed of with a direction that no eviction drive consequent to the notice dated so and so issued by the respondent number 4 shall be carried out in respect of the parcels of land which were allocated earlier inside the NS Solamona Forest Village under Longboy Reserve Forest Reserve in the name of the predecessor in interest of the petitioners, with the further observation that this court has not made any observation with regard to any eviction drive carried out beyond such parcels and of land allocated inside the Longboy Reserve Forest. So, but this order was made subject to paragraph 7, my lord will see. It is further observed that any further eviction to be carried will be subject to outcome of the decisions in the pending writ petition number so and so.
What is this writ?
In this writ petition, my lord, Honorable Single Judge has clearly held that for non-forest activity cannot be resorted to inside a forest. At best, they are entitled for making a claim under the Assam Land Policy of 2019. So Government of Assam's Land Policy of 2019. That was assailed before the division bench. The division bench also affirmed the concurred with the judgment of the single bench.
251.
Yes, 250. Not 250. That's a different writ petition, my lord. So, my lord, I am not on that also. If my lord perishes my instruction now, my lord. And other writ petition, my lord, the direction was to, my lord. Direction was to submit a representation. Now, my lord, may kindly perish my instruction, my lord. With reference to the subject and case cited above, the following factual and legal position with regard to the petitioners is respectfully submitted for kind perusal and necessary use before the Honorable Court. Number 1, clause, paragraph, my lord. Petitioner numbers 1, 2, 3, and 5 are the legal heirs of the original allotee of North South Solamona Forest Village. It is submitted that they are not residing within their duly allocated DAG land and are presently residing outside the same. Though some members of their family continue to reside within the allocated DAG, it is further submitted that they have encroached upon reserve caste land for establishment of community facilities and or other purposes within the forest village area falling under the jurisdiction of the Longboy Reserve Forest. Such occupation continues unauthorized encroachment over reserve forest land prohibited under section 24-25 of the Assam Forest Regulations 1891, which empower the Forest Department to evict encroachers from the reserve forest. Accordingly, eviction notices are issued directing removal of the encroachment, vacation of the encroached reserve forest land, and the settlement within their own allotted DAG land. The eviction notices were issued strictly in compliance with the directions of the Honorable Guwahati High Court passed in writ appeal number so and other relevant judicial orders. As such, the petitioners may be required to submit their representations, if any, against the said eviction notice to justify their claim over the land falling within Longboy Reserve Forest and beyond the notified boundaries of the South Solamona Forest Village. Petition number 4 is an encroacher who has unauthorizedly occupied land within Longboy Reserve Forest. The claim of the petitioner is that he is a resident of all Solamona Forest Village is not sustainable as the encroached area lies outside the notified boundary of the said forest village and squarely within the reserve forest land. Such occupation is barred under so and so. Next paragraph, my lord. Petition number 6, 7, and 8 are the legal heirs of the original allotee of Old Solamona Forest Village. It is submitted they are not residing within their allotted land, DAG land, and are presently residing outside the same. Though some members of their family are residing within the allotted DAG. They have encroached upon the reserve caste land within the jurisdiction of Longboy Reserve Forest. Such encroachment again violation of so and so. Then paragraph 4, petition number 10 and 9 and 10 are legal heirs of the original allotee of Shambhunagar, Kanakpur Forest Village. It is submitted they are not residing within their allotted DAG land and are presently residing outside the same. Though some members of their family so and so. And then they have, my lord, mentioned about Forest Conservation Act.
And you have to bring it on record.
But what I suggest, my lord, apparently, my lord, what has happened, my lord, in respect of these petitions, well, their forefathers were allotted inside forest village. They've gone beyond the forest village now. And just to, my lord, make out a case, they are resorting to the earlier orders. Sorry, earlier, my lord, allotment orders made in favor of their fathers, clearly suppressing the fact that they have gone beyond that area, my lord. And if we see the last order, my lord, the second writ petition order, They don't have to even claim, my lord, that they are entitled under the Forest Rights Act. Their forefathers are already allotted because of their expansion of the families, my lord. They have gone beyond the area, and all the time we issue notice, they say we have been allotted. Yes, it is true they have been allotted, but they are not residing in the allotted area. They have gone beyond that. That is why notices are issued. So our eviction will be, my lord, only confined to areas that falls within the reserve forest, not within the old Salamona forest village, my lord. Because they cannot go beyond that. If they have some difficulty, my lord, they should go somewhere else, my lord, not
What
forest.
do you say, Mr. Borthakur?
Lord, so
What I suggest, my lord, what I suggest, my lord, let them file a because pursuant to this notice, they have not filed any representation. Let them file a representation to the DFO, my lord. He will take them into confidence. We'll visit this place. We'll identify the area where they are actually encroaching. The matter ends, my lord. We'll not evict them if they are. We'll not evict them till they are inside the forest village. Not in respect of, not in my lord reserve forest. My lord.
Lordship, that's a fairly submission on the part of my learned additional AG, your lordship. If we have encroached your beyond the land allotted to us, then yes, absolutely we are liable to be evicted, your lordship, no doubt about that. But since there is no question of misrepresenting, since our claim is that, your lordship, we are within that forest village, your lordship, therefore not.
That's why I'm saying, my lord, instead of my lord deciding these disputes, my lord, let them file a representation, making a claim, will identify the area wherein they should be residing.
Lords. That
will suffice everything.
Within a specific period of time, and we should be taken into conflict.
Definitely, my lord, definitely.
While
Provided they could be found there, my lord.
Lords.
They could be found there, my lord.
We will
Otherwise,
also-
I know,
Council for the petitioners, Mr. Ian Goswami, additional AG, appearing for the state. Petitioners are aggrieved that although they are residents of the forest villages at NS Solamona, Old Solamona, Sambhunagar and Kanakpur in Sribhumi districts, and the families of the petitioners have been residents of these forest villages for about a century, and they fall within the category of, within quotes, other traditional forest dwelling as defined in section 2O of the scheduled tribes and other traditional forest dwellers within bracket recognition of Forest Rights Act 2006. Stop. Earlier, they were issued eviction notices in the year 2023 when they had approached this court by filing WPC 946 of 2023 and WPC 2540 of 2023. Stop. Both these petitions were disposed of. While WPC 946 of 2023 was disposed of, with the direction that no eviction drive shall be carried out in respect of the lands which were allotted to the predecessor on interest of the petitioners, WPC 3540 of 23 was disposed of, granting liberty to the petitioners to submit their representation before DFO, Longai Forest Division, Karimganj, to justify their continued residence in the forest village and to file and relevant documents. So, the divisional forest officer was required to provide an opportunity of hearing and decide the representation within 6 weeks from the date of the order passed by the court. In deference to the said order, it is the claim of the petitioners that they have filed their representation before the DFO. However, no orders have been passed, and instead, notices, eviction notices were again issued to the petitioners. Where are the eviction notices again?
Page 55.
2/1/2026.
Eviction notices were issued in respect of the writ petitioners on
58, my lord.
58.
2/1/2026
26.
by the DFO. Stop. Being able to present writ petition of the implies. The matter was listed on 3001/2026 when it was deferred on the request made by the counsel for the petitioner. Stop. Today, when the matter is listed, the learned additional AG, Mr. P.N. Goswami, submits that on written instructions that upon a detailed, that the representation which is enclosed at
Annexure 4.
annexure
4.
page number
It's
47.
Page 47, my lord.
The representation dated 3006/2023 stated to have been filed before the respondent authorities in deference to the order dated 2006/2023 passed in WPC numbers 2540 of 23, has not been received by the Forest Department. Stop. It is the claim of the writ petitioner that no such representation was ever filed. Stop. The learned additional AG, however, submits that even today the writ petitioners prefer representations with all relevant documents, then taking into confidence the representations, taking into confidence the writ petitioners, the matter would be examined and each of the case of the petitioners would be individually dealt with upon joint verification.
Not required, my lord. They're not saying it's a revenue land, my lord. When it's a claim of revenue land, my lord, then the joint revision required. The DFO will do everything, my lord. Let them visit the DFO, my lord.
We'll examine each and every matter individually and thereafter pass appropriate orders. Stop. According to the information available with the Forest Department, the petitioners,
All the petitioners actually.
all the petitioners, besides their allotted plot of land within the Longai Reserve Forest area, have also extended their claim beyond the forest area.
Beyond the, my lord, forest village. my lord.
Forest villages.
North, south, Solamona forest village.
North, South, Solamona
Forest
forest villages. Stop. Therefore, it is in respect of these plots of land which are beyond the
Forest.
boundaries of the North, South, Solamona forest villages that the petitioners are required to either vacate or be subjected to eviction procedure by the Forest Department. Stop. Insofar as the allotted plot of land within the North-South Solamona Forest Village,
No eviction will be carried out.
which is stated to be under their possession since from the days of their predecessor in interest, no eviction process will be carried out by the respondent authorities. Having perused the written instructions placed before the court by the respondent state, and also upon taking into consideration the submissions made, this court is of the view that the writ petitioners will file their detailed representation before the DFO within 1 week from today and supported by all necessary documents. Stop. Once the applications are filed, the DFO will examine each and every case personally, individually, and thereafter pass appropriate orders within how many days?
15 days, man.
15 days, therefore. Accordingly, the writ petitioners will file their
7 days from today.
applications within 9th of February.
Yes.
And the DFO thereafter will pass appropriate orders by 25th of February on such applications made. Stop. With the above observation, the writ petition stands closed, disposed of.
Lordship, there are two other forest villages, your lordship, Sambhu Nagar and Kanakpur, your lordship. Apart from also Namarak. Sambhu Nagar and Kanakpur.
This is not referred to here.
Yes, here it is. In the instruction, your lordship will find that page, para 4.
There are four. Sambhu Nagar and Kanokpur Forest Village. The Tinta village, Forest Village.
9 and 10.
Then there is a NS North South Salamona Forest Village. One is Sambhu Nagar and the other is Kanokpur Forest Village. Huh?
Well, four villages. If they don't file representations, well, we'll proceed under as per the
In
eviction
the
notice.
event the petitioners do not file any representation as provided by the court, the respondent authorities are at liberty to proceed as per the procedure prescribed in the law. It is also made clear that once any representations are filed with the DFO, proper acknowledgements be issued by the DFO. So disposed.
Obliged.
My friend has taken this take time to bring instructions.
The instructions?
Lordship, the instruction is that, Lordship, the petitioner has approached this court with not clean hands, Lordship. With not clean hands. Why I am supporting, means why I am raising this contention, because.
What is the instruction?
Because the page 9, they have stated some dark numbers of the land. That the land belongs to these dark numbers. Lordship, look, have got the copy of the Sitha, Lordship, latest Sitha copy. They are the dark numbers which they have mentioned in the petition is also reflected here. But all the dark numbers are shown as a government land. Nothing is there. Lordship, may kindly peruse the. I have highlighted the dark numbers also.
Our case is also that only. Land is government land, but we are occupying since independence from our others forefathers. And the authority also granted Toji Patta. They are also paying Toji revenue. But without following the guideline of the Honorable Supreme Court and as well as this noble court, directly issued eviction notices.
What is the guideline here?
It also can be say page 145, the Supreme Court. At least they give opportunity to allow me to submit documents, hearing. Nothing has been done by me. Page 146 is the order.
Yes, Mr. Das.
Lordship.
So they say that it is a government land, but they are occupying.
They are doing for only agricultural purpose. They are not staying there, Lordship. Their residence is not there, which they themselves have admitted.
No, yes, correct, my lord. I was open.
They are only cultivation, Lordship. Only for cultivation, Lordship.
But they are also paying some revenue.
No, revenue taking has already been stopped, Lordship. Already been stopped, and that has already been reflected in one of the this judgment passed by Justice Manish Chaudhary in case number 7516 of 2019, Lordship. Lordship.
Page 26, my lord. We are paying onwards 1979.
When was the last payment made?
Last payment, my lord, some 16, 19, 2020, my lord.
24, 25.
Then
no,
thereafter they are not receiving.
After-
But we are paying. But
how can
question is, my lord, they give an opportunity to give me we should produce.
What opportunity?
My lord,
You agree that these are government land. You agree that these have been under your occupation for last so many years. What opportunity do you require?
My lord, let the issue notice. We reply.
Notice to
Then
what?
hearing, my lord. Then hearing.
Mr. Counsel,
After eviction notice,
what
my lord.
reply are you going to give other than whatever you have stated here? You are going to say that this is under your occupation.
Yes, my lord.
Is there any other factual detail in your favor which, according to you, the authorities are unmindful of?
My lord, you lost eviction notice. Whether those land has been earmarked for water resource department, whether any notification has been issued. Nothing, my lord. They should have issued at least notification that that land is reserved for water resource department. Nothing has been done, my lord. Now randomly they are going to evict us, my lord.
No, but any land What makes you feel that any land which is lying unused is not government land? You utilize the land, but you have to file necessary applications for conversion into patta. That you have not done.
Now, there's some of the petitioner already earlier they applied, but not, no decision has been taken. Since their fathers, now petitioner are sons and grandsons of those persons. And so as petitioner number 1 is concerned, he is alive. Let me give some chance be given to me, we make a representations and take a decisions. Proper decisions should be taken, my lord.
So what proper decision do you want? Every time a notice is issued, you come to the court, ask for further notice, opportunity.
My lord.
The entire process
My lord.
prescribed in law gets frustrated.
Yes, my lord. Illusion can listen. Whether I am in government land or illegal occupy, but they should follow the rule of law. They should follow the instruction given by the Honorable Supreme Court as well as this Honorable Court.
You know where you are occupying. It is not your case that pattas have been allotted to you and you are in occupation of the patta land. In spite of that, eviction notices have been issued.
My
You
lord,
are making a statement that you are in occupation of land which is admittedly government land.
in another case, my Honorable Supreme Court held that maybe government land, maybe another lands, except forest land, so and so. They cannot do it. That decision also taken in Manoj Tiwari Akash case, my lord.
Let us see.
2020.
Let us see. Which paragraph? Paragraph.
Yes, paragraph, my lord. Uh, 25, page 10. Yes, I have my lord, but guideline is my lord. Illusion LDC, page 13, paragraph 30, my lord, thereafter. Before acting in person of the road widening project, the state or its establishment must.
Paragraph?
Paragraph 30. Must ascertain the existing wide of roads so and so, carry out the survey of demarcation, ascertain whether there is any encroachment of existing road with given roads maps.
This is a matter with regard to demolition of a house.
But finding is there, my lord. Finding is there. Thereafter, page 31. In the present case, we conclude that the entire process which was followed by the state was high-handed. We therefore direct as follows. The state must make payment of punitive compensation.
No. This is not applicable to you. This is the case of demolition of a house. Because of widening of the road.
My lord. But same, that is also in page 146. It was page 146. And then, my lord, another judgment, writ petition civil 295/2022 on all Supreme Court, my lord. I have the one copy, I give the this, my lord.
First, you show us under what? You show us
whether illegal or illegal.
You show us under what provision of the rule or the law that you are entitled to a notice.
Because we are occupying, we are occupying since long back.
You are occupying knowing fully well that this land is not allotted to you.
Not only in that case also, in monastery case also, they illegal occupied.
Please see what statements you have made. These have been in possession since independence.
Yes.
And some of the petitioners have also paid TOSI revenue.
Yes, ma'am.
Then used for cultivation. There are 3 they have been cultivating their respective plot of land.
Our residence nearby, my lord. Nearby and village.
Is your residence sought to be demolished?
No, residence, no, sir.
These are agricultural land which has been under occupation,
No.
and this land is reserved for the government. You have been paying towards the revenue.
No.
You have not made any application for allotment of the same in your favor. What were you doing?
My lord, page 16 of my deed petitions, paragraph 11 onwards, my lord. I give the judgment also, place this judgment also, my lord.
No, judgment is on
Yes,
each and
my lord.
every fact.
Issue certain guidelines.
Hmm.
Your lordship kindly see. Has issued certain guidelines regarding demolition, eviction, and paragraph 1991 of the said judgment are read as follows.
No, you tell me, how are you prejudiced without the notice being served? In a sense that what other statements are you going to make?
Because,
Is
my
it
lord,
your case? Is it your case?
if they give a chance of hearing,
What will you project before the
my
authority?
lord, and the documents we will project, then if they rejected our claims, then we make an alternative prayer before them.
What
That is
alternative
alternative prayer because we have that cultivation is there now.
What
so
stops you?
at least we
What
take
stops
some.
you from approaching the authority and making that prayer now?
We are not claiming allotment now, but we'll get a chance.
No.
Before the authority that sometimes be granted given to
No,
us
no.
to
Not like
remove our petty
No.
crops, my lord.
We can't, you cannot twist the provision of law, untwist it, knowing fully well that you are not entitled to the benefits under the law. Cannot be permitted. You are occupying land without authority. You have never applied for settlement of the same. Now you want to continue doing it and then negotiate with the government to give you alternative land.
No alternative land, my lord.
Then
At least we can make a prayer before the
you
authority.
make a prayer. Who's stopping you?
That
Open make a prayer.
some time may kindly
No,
be
you make
given.
a prayer.
That observation, my lord.
Observation will give you. Learned Council for Parties.
That observation at least 2 months or 3 months time.
No, not 2 months. Not 2 months. The writ petitions have been filed by the petitioners who claim to be in possession of the land. Where is the schedule of land?
Schedule not mentioned there, my lord. It notice or illogical particular notice.
No, in your writ petition, what land are you occupying?
I mentioned the DAG number.
Where?
In paragraph 3.
The writ petitioners.
And the notice schedule is there and the DAG number has been mentioned.
The land.
Page 93.
For cultivation purpose. And the particulars of the land, quantity of land and the DAG numbers in respect of each of the petitioners are mentioned in paragraph 2. Stop. Petitioners are aggrieved that these land have been in occupation. The petitioners are in occupation of this land since their forefathers, and they have paid Tozi Bahira revenue to the department since 1969. Stop. The department collected the revenue till the year 2022. Stop. Thereafter, the department has refused to accept the revenue. And
Next to is the notice.
the petitioners were shocked to receive the eviction notices issued, asking them to evict from and vacate all the lands, asking them to vacate the land under their possession, failing which eviction proceedings shall be carried out under Rule 18(1) of the same regulation. Stop. The Learned Counsel for the petitioner submits that no prior notice has been issued, permitting the petitioners to submit their representations. Stop. The Being aggrieved, the present writ petition has been filed. Where Mr. R.M. Das, Leonard Standing Council Water Resources Department has submitted before the court that the land in question is allotted, is reserved for the Water Resources Department.
Government land and reserve for water.
Government land and reserved for Water Resources Department. And the same is now necessary for purposes of use by the Water Resources.
But no notification has been issued.
Stop.
What are it is?
Yes, Learned Counsel for the petitioner submits that whether the land is to be utilized for Water Resources Department, no notification was issued. And the same ought to have been issued by the department, and a further notice has to be given to the writ petitioners. Stop. Being agreed, they are before this court. Where, having heard counsel for parties and upon perusal of the writ petition, it is seen that there is a categorical averment made in para 2 of the writ petition that the petitioners are using this said plot of land for cultivation purposes and are also paying TOSI revenue to the government. And these land have been in the possession of the forefathers of the petitioners for last several years. Stop. It is therefore evident that these land are not allotted to the writ petitioners. Stop. The petitioners also do not dispute that these are government land, and for use of the same, they are paying TOSI revenue. Stop. The only grievance is that no specific notice have been issued to the petitioners to vacate. Stop. There is no averment in the writ petition that the petitioners had applied for allotment of the said land to the writ petitioners for cultivation purposes or for their use, in spite of the land being under their occupation and oblique their forefathers for the last several years. Stop. The only grievance of the petitioner urged before the court is that no specific prior notice has been issued before issuance of the eviction notices.
As per the Supreme Court guidelines.
As per
the guideline issued in page 147 or 46.
Stop. In this connection, the counsel for the petitioner has referred to the order of the Supreme Court rendered in Abu Khair and others versus State of Assam, where certain guidelines were issued.
And also order passed in WBC number page 148, my lord.
Has also passed. As also similar orders being passed. Before the authorities. A similar order is passed by this court. So the order passed by the apex court is extracted below page 146. So considering the submissions made and the orders passed by the apex court as well as by coordinate benches of this court are considered. The court is of the considered view that the writ petition need not be kept pending and it can be disposed of by permitting the writ petitioners to file their individual representations along with all necessary documents before the
District Commissioner.
Who has issued these?
Circle officer issued.
So you file it before circle
Yes,
officer.
Respondent number 4.
before the respondent number 4 within 7 days from today. Stop. The respondent number 4 will thereafter examine the matter and pass appropriate orders individually. Examine each case individually and pass appropriate orders within 30 days.
Lordship, regarding the hearing.
Yes.
Hearing which my learned friend is pursuing before this court to hear them. Lordship, that notice has already been issued.
Where is that?
That notice has already, one is the eviction notice, this one.
142 is
140. This one is general notice for eviction is 128. That has already been issued. Another notice, Lordship. This one, Lordship, on 22/1/26, that notice has already been issued. I
We
don't
are
know
not,
why.
we are not receiving any.
Where is that?
Lordship, this is the copy, Lordship.
No. Is it enclosed in the writ
No,
petition?
I don't know. I am surprised.
General notice has been.
No, we are not receiving that notice, my lord.
Huh?
We are not receiving.
General notice has already been enclosed in one
If we
page.
receive that notice, immediately we may submit the application, my lord.
General notice has already been, that is enclosed in page 120.
Whatever notice we receive, we annex, my lord.
Individual notice has already been issued.
As for eviction. Page 62, my lord, or notice dated 21/2/2026.
Within 3 days.
No, probably all the DAG numbers which are reflected in the writ petition are not found in your notice. There are some additional DAG numbers.
As a whole, notice has been issued.
But they must be served with the notice, no? How will they know?
Lordship, I think they have already been served because this is issued on 22/1, on the same date that eviction notice was issued.
That notice we received. That was we are not received, my lord.
I don't know.
How?
Illegal, no? Last order.
If we got that notice, we immediately we submit our representation.
Huh? Pass appropriate orders within 30 days from the date. Pass appropriate orders within 30 days. Therefrom, stop. The petitioners will positively file their application by 9th of February 2026. And the respondents, the circle officer will thereafter pass appropriate orders by 25th of February.
Till then, the order is continued.
Since the petitioners are represented by their respective counsel, no separate notice is required to be issued to the petitioner at the time of hearing. Stop. Till 25th or till such time, till 25th of February or till such time the circle officer passes the orders as directed.
Only
No process for eviction in respect of the DAG numbers of the writ petitioners shall be carried out.
my lord, only the thing will be, my lord, the application will be filed before the DC and DC will conduct a hearing himself or by any representative authorized by him.
Not
Other-
circle officer.
Not my lord. Otherwise, again, they will come, the circle officer will not be the authorized person, it should be DC.
No problem, we have no problem. We,
Like, instead of circle officer, you make it the DC.
And DC will conduct the hearing himself or by any authorized representative.
DC Moreno.
DC will examine the matter himself or by any other competent officer authorized by him.
Yes, ma'am. Highly obvious.
notice,
Not below the rank of circle officer.
Yes,
yes.
Hmm.
Then notice, এটা পুরো আমার না এটা ঘুরে দিন।
DC মানে district commissioner, Morigaon district. Respondent number 3.
Now, copy of that notice may serve.
What notice?
Already, your lordship.
What notice?
That notice.
Already.
That notice is irrelevant.
Yes, lordship.
Irrelevant, no?
I love it.
Till 20th or before that. Till 20th or before that.
25th.
25th or before that.
Before that?
Lordship, briefly on that.
Yes, 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 yes.
Item 33.
Met his lordship.
No show cause.
For instruction, my lord, I would like to, let it be in the motion stage. Only on that point.
Instruction.
First day, my lord, in all cases, at least.
All right, State Council will obtain instructions list on 6th of February.
Much obliged.
You give a copy of that order.
My lord is there. Item 34 is similar, my lord.
34 also, 6th of February.
Much obliged, lordship.
35.
Order of copy to order.
Please, my lord.
Yes.
This matter pertains to land settlement. Both the petitioners, my lord, are landless persons. They filed application before the SDO civil on 21/12/2010, my lord. Thereafter, we filed application on the year 2010, my lord. It is in annexure 1, my lord. Thereafter, there was land allotment proposal was issued, land valuation was fixed, premium valuation, everything was fixed. Our documents were, every documentary thing is, a part is completed. And the only issue is, my lord, they have to issue the premium order, which will be paid by us. With that regard, my lord, we have filed an application before the DC. Lordship will find it at page number 28. We filed this representation before district commissioner to issue that premium order. That part is left only. We are allotted, we are in possession. Everything is documentary, part is everything completed. Just,
When was the allotment order issued?
my lord, allotment proposal, my lord, will file in page number. It starts from page number 16, my lord. Allotment proposal. 2015, my lord. 2010, my lord, 21/12/2010, there is assistant settlement officer. This is the allotment proposal. Page number 17. 16 is the type portion. 16 to
21/12/2010.
same.
When did you file your application?
My lord, it is the same, it is also showed as 21. Lordship will kindly come to page number 15, my lord. There is lordship in, it is the same 21/12/2010. The date goes on to show in the left part, bottom left, my lord. It is signature of the civil SDO. This was forwarded to the circle officer for land valuation allotment proposal.
2010, my lord. It had been only allotment proposal, my lord. It has not been allotted.
No, my lord, lordship will
And from 2010 to 2016, my lord. Representation has been filed on 2015/12/2025.
Lord, it is, my lord.
Why they have come after such a
Why
long
don't you
time?
go and file an application before the DC?
They say,
Lordship will kindly come to page number 26, my lord. Now, there was a SDLC meeting held. By this, we have been allotted this land, my lord.
You go and file it before the DC. Why are you coming before the court now?
We filed in representation before DC also, my lord.
So go and pursue it.
My humble submission is because it is already, it was submitted in the year 2025. Just a, my lord, direction to dispose
No,
of this
not
petition.
like that. Don't treat the court to be a panchayat office. You are coming here assailing, demanding a right. You are unable to establish a right. 2010 something, you have filed something, somebody has given an order, and you come to the court asking a direction that we should go and dispose it of. You go and file, pursue this matter before the DC. File it. File it. What has happened before the DC?
We have filed representation. It has
Only one
left.
month, my.
It
That
is filed in
2010 proposal, 2019 land policy has already been given effect.
No order passed, go before the revenue board,
my
next higher authority.
Yes.
only prayed for that, my lord, that.
You
that
may
my
pray for
representation
anything.
be
Mr.
considered.
Counsel, please understand something that these are factual issues.
Yes, I totally understand.
Then
but just
how do you expect the High Court to pass an order without knowing, understanding what is the factual issue, why it was not granted, why the delay was there? This is not what we are supposed to do unless you say that no, all the authorities have, all your forums have been exhausted. Nothing is coming out of it. Go and file before the revenue board. This is a higher appellate forum. Why this representation has not been
taken into consideration.
considered in spite of being filed on 15/12?
So that issue, my lord, I have just made that let it be, let a direction be given to. at
Why
least
should
take
we
it
give
into
a direction
consideration.
without knowing what is here? Why are you presupposing that the DCA is slipping over it, doing nothing? It is possible that your representation may have, some order may have been passed, may not have been passed. There is a structure in the rules.
Yes.
You have to give an explanation why that forum is not a correct forum and
No,
you have to come before the court.
We are at liberty to approach, we'll approach, but that's why I have made the prayer to just take it into consideration. And we have the way to go to revenue board, I understand, my lord.
Go and urge the matter to the revenue board, why it has not been done. So that if nothing happens, we are here. At least some factual material will be there. There is no factual material here from the respondent side.
Lordship will kindly come. They have already said that they have already acknowledged our position, our.
No, they have acknowledged everything since 2010.
2010.
And you have filed a representation in 25 and nothing has happened.
New
This
land policy
will
also.
require examination of that particular file where your allotment has been granted. So this is to be done effectively by the revenue board. They can do it. Why it has not been done?
That observation will be made.
Heard learned counsel for the parties, the petitioner is agreed that in spite of land being allotted to the petitioner, measuring 2 bighas, 1 quota, 8 lachas, under DAG number 365 of /120 of village Odomtola, part 2, on the basis of the applications made, the revenue required to be deposited has not been intimated to the petitioner by the revenue department. Stop. The allotment of land was communicated to the petitioner as far back as 2010. Stop. Thereafter, the petitioner has also approached the district commissioner Dhubri by representation dated 15/12/2025, ventilating his grievances, but no orders have been passed on the said representation. Thereafter, under the revenue regulation 1886, in the event the deputy commissioner in the event of a grievance against orders against the action or inaction of the Deputy Commissioner's office, further appeal lies to the Revenue Board. Assam. Stop. The petitioner is at liberty to approach the Revenue Board and seek for appropriate remedy. Needless to say, if the grievance still remains unredressed, petitioner is given liberty to approach this court.
Obligation.
Okay, Lordship, pursuant to the land acquired, my lord, we have been directed to appear for release of the award, page 19, my lord. And notice was issued to us, and accordingly, every documents we have submitted. Last line is there, discuss on the share and report of their land acquired in the aforementioned project for onward submission to the Deputy Commissioner and receipt of awards. Afterward, my lord, this all requisite document was sent to the, my lord, the concerned officer, additional Deputy District Commissioner, Land Acquisition Branch. Now, my lord, that only payment has to be released, my lord. Delay is caused, my lord. So my limited prayer.
This is the Kala.
Yes, my lord. Now, my lord, only limited, my lord, submission subject to all clearance of norms, my lord, whatever they have to take.
Can you get instructions, Mr.
Your Lordship, I will get instruction, but one thing I just point out to your Lordship, the land is acquired on behalf of the Aerotropolis Development at Guwahati LGBI. They have not been made a party. So, yeah, we have to, if that amount is released from them, we are only disbursed.
No, you find out whether the amount has to be released.
Yes, Lordship, that
Amount has
part.
to be deposited before acquisition.
Yes.
So if it is acquired,
Most probably it is acquired as because from the record, but whether that amount is released or not.
We have visited the office. We have visited the office. Amount is there. Only, my lord, because the, my lord, official acceptance, my lord, delays for, my lord.
I can get that instruction, Lordship, whether the amount is released by the authority.
why are you using a constituted attorney?
My lord, the persons who are, my lord, beneficiary presently are not available at, my lord, here. Yes, ma'am.
They are not available.
Yes, ma'am. But at the time of, my lord, they have appeared there before the authority in person.
So they are not available where?
My lord.
Where are they not available?
My lord, right now, my lord, not in India, my lord. That's why this has been instituted by the power. But
Where have you made this statement?
My lord, I have made, my lord. Paragraph 1, my lord.
Paragraph?
Paragraph 1, my lord.
1.
Page 5. But during that period, my lord, they appeared, my lord.
All right. Heard counsel for parties.
And Kala is also not made a party here, Lord.
The only thing is that, my lord.
Kala is additional district commissioner.
Yes, Lordship.
He is respondent 3.
Respondent number 3, but Lordship, it should be
Not as
competent
Kala.
authority, not as Kala. But even then, Lordship, I can get that instructions.
The petitioners are agreed that their land covered by DAG number 946 and 947 and Patta number 457 was acquired by the Aerotropolis Development at Guwahati LGBI Airport. AEROTROPOLISH. So the petitioners are presently residing in Canada, and therefore they have authorized a representative, namely Subimal Chakraborty, to represent the petitioners. Stop. The only grievance of the petitioners is, in spite of the land being acquired, the amounts payable to the petitioners have not been granted. Stop. The application, the representation. Your representation.
My representation, we are personally appearing, my lord.
Huh?
The page 21 already, all documents has been sent there.
No, but it doesn't appear to be complete.
Yes, my lord. Only last part, my lord.
No, it
But
doesn't
on
appear.
top, my lord, direction is, my lord, submission of DAG number is there, my lord, 946 for 947.
It doesn't appear to be complete.
We'll
The
file it.
representations have been stated to be filed before the additional district commissioner and in charge land acquisition branch, Kamrup Metropolitan District. And however, the compensation has not been released. Where? Mr. H. Sharma, learned Government Advocate, will obtain required instructions in the matter and apprise the court on the next day, list on 13. Is this 13 all right for you?
1-3.
1-3,
Lordship.
13th February. Although notices are not issued, extra copies we furnished within the course of the day. Good of answers.
Well, although I'm appearing this side, actually the writ petition and the interlocutory application under Article 223 have been listed together. Now, this is a case
Yes.
where they would like to argue first.
Then why are you arguing?
No, we stood in the wrong side, my lord. They should have come here.
Yes.
Yeah, my lord, this interlocutory application, my lord, has been preferred under Article 226(3), my lord, for vacating an expert order, my lord, interim order, my lord. The lordship will find the interim order, my lord, at page 20, my lord, and it's a 3, my lord.
Correct, sir?
And it's a 3, page 20, my lord.
Okay.
I have to go.
Here, my lord, what when, my lord, an annual general meeting, my lord, was held, my lord. In the general meeting of the cooperative society, my lord, a large number of anomalies were there, my lord, some false signatures as well as some signature of the date shareholder also, my lord, or truth, my lord. And being agreed at that general meetings, my lord, resolution, my lord, the applicants had raised some objection, my lord. And accordingly, my lord, inquiry was conducted, my lord, and inquiry was found to be genuine, my lord. Thereafter, my lord, the instance register of the cooperative society, my lord, that is to the water, my lord, you also will find at page 18, my lord.
80 of
18, my lord. Of
18.
the IMI.
IA. Yes.
So, my lord, this is the water, my lord, passed by assistant register of cooperative society, my lord, Hailakandi. My lord,
This was stayed.
yes, my lord. And it was, in fact, these are the challenge in the repetition, my lord.
Mr. Bonik represents the
Writ petitioners, my lord.
writ petitioners.
My lord.
You are agreed by this order,
We are agreed by this order,
impugned order.
impugned order, my lord.
No.
We challenged in the writ petition,
Represents.
the
who
inquiry
are you
report.
representing?
My lord,
Mr.
I am the shareholder, my lord.
Shareholder.
In fact, I am the respondent number 9 to 14 of the writ petition, my lord.
You are not arrayed in the writ petition.
Yeah, right, right.
Arrayed.
Yes, my lord. Well, there is a provision, my lord, of section 111, my lord, of the Cooperative Societies Act, my lord. As per that act, my lord, they could have prepared an appeal before the, my lord, register of cooperative society, my lord. My lord, they have the available alternative remedy, my lord.
Your respondent number
9 to 14, my lord.
9.
9 to 14.
No, 9 to 14.
Yes.
All right. When was the interim order passed?
Interim order was
2910.
passed in the recruitment, my lord, it was passed on, my lord, 29/10/2025.
No. So you filed it in 19 November.
Yes, ma'am.
Petition.
Yes, ma'am.
My lordships.
14 days.
No, so far as Recovery Ringa is concerned, my lord, the full bench judgment on Article 226(3), it clarifies, my lord, that the date on which the application is listed before the honorable judge as per the roster, the count of 14 days is from that time. The matter was listed on the 5th of January,
Let us see the full bench judgment.
my lordships.
Paragraph.
45, internal page 39. May I read that, my lord?
Internal page 39.
39.
Hmm. Yes.
May I read? Accordingly, we decide the reference as herein under. 1. Article 226(3) of the Constitution
You are
is
reading from para 39.
paragraph 45, page 39. Lordship has it.
Yes.
1. Article 226(3) of the Constitution is not a directory provision. 2. An order referred to in Article 226(3) of the Constitution is an ad interim order. The said ad interim order is required to be limited duration, or in other words, the existence of the ad interim order has to be limited to a date so fixed. 3. The ad interim order is converted to an interim order only after an opportunity of being heard is granted on the prayer for interim relief to all the parties to the proceedings. 4. The High Court on an application filed under Article 226(3) of the Constitution may reject the application or vacate, modify, and/or alter the interim order, or may extend the ad interim order in the presence of the parties to the list. Once the ad interim order is extended after hearing both the parties, it shall then be converted into an interim order, and the prescription of automatic vacation of the ad interim order for not being disposed of within 2 weeks cannot be applied. However, the High Court can still vacate the interim order on grounds vis-a-vis when the litigant, after obtaining an interim order, deliberately prolongs the proceedings either by seeking adjournments on unwarranted grounds, or remains absent when the main case in which the interim relief is granted is called out for hearing before the High Court with the object of taking undue advantage of the interim order, and/or when the High Court finds that the interim order is granted as a result of either suppression or misrepresentation of material facts by the party in whose favor the interim order of stay was made, and/or the High Court finds that there are material changes in the circumstances requiring interference with the interim order passed earlier. The above grounds so stated are not exhaustive, and there can be other valid grounds for vacating the interim order. Now, the term court makes an application to the High Court, unquote, and quote, the date on which it is received, unquote, would mean when the application is filed seeking vacation of an ad interim order is placed before the learned judge who is holding roster as endorsed by the learned Chief Justice of the High Court, and the date on such application is listed before the learned judge for the first time. That's all. So the earlier concept method which we had, that the moment it is listed, the petitioner would rush to make a mention to have it listed within 14 days. That stands altered by this honorable full bench judgment, my lord, which says the moment my lord has it on the roster and is listed, and I've read the judgment, it leads to the analogy diverging from the Gujarat High Court judgment, my lord. It says that not mere filing would suffice before the registry. It has to be listed before the honorable judge, and that would be triggering point. 5th of January 2026, the matter was first listed. Notwithstanding that, the matter was extended in presence of the parties. Well, I can still argue the matter. That's okay. But automatic vacation is still not in the way. Better, my lord?
Yes.
Lordship would hear the matter together, the entire matter.
Why?
Okay, I'll address on the facts, my lord.
Why? Why together both the matters?
I mean, the main matter and the interim can be heard together.
Why should we?
I'll leave it to your lordship. We'll address it.
As an interim order, we are to see only whether the interim order needs to be vacated by operation of law.
My lordship.
What do you say with regard to the full bench judgment?
My lord, I have not gone for this judgment, my lord.
You have come to the battle with your gun and you are asking for bullets from the other side.
There is not actually the fact.
Oh, wonderful.
Yeah, my lord, the case, my lord, the case
That will
was,
be listed after in the next week.
The interim order continues.
Interim order. That will again put the carpet under you. Think about it.
My lord, I think, my lord, the entire matter should be heard with the my lord.
The entire matter should be heard, then we'll dismiss your IA. Why should you keep the IA pending?
My lord, that
We'll
can-
hear it as
Yes,
per
yes,
the
that can
convenience
be
of the
done.
court.
Yeah, yes.
Yes, what?
I may be allowed to do the IA, I will continue.
You
the-
want to withdraw?
Yes, my lord.
Heard learned counsel, Mr. S. Hawk, counsel to the petitioner, in view of the submissions made by Mr. A. Bonik appearing for the writ petitioners, referring to the full bench judgment of this court rendered by judgment and order dated 13/8/2024, passed in writ appeal 250 of 2022. The counsel for the petitioner, for the applicant in the IA seeks liberty to withdraw the IA. IA accordingly stands dismissed on withdrawal. In the writ petition, pleadings are exchanged.
Yes.
The IA having been withdrawn, the interim order passed earlier will continue until further orders. The matter be listed for admission hearing in the month of March.
My lord, can we first week of March? my lord?
First week. First week.
Date me kindly please. my lord.
Date.
Fourth of March, my lord.
This first week is not possible. 10th of March.
Fine.
Grateful, my lord.
List on 10th of March.
Fine.
Obliged.
Obliged. Right, please, Lord. My lord, I have filed IA, my lord, in WBC number 5018 for implement, my lord. My lord,
IA?
one,
also.
one, my lord, Moinul Haq, he is the, my lord,
What is the IA number?
IA number 13113.
Huh?
3113.
Who is for the other side? Anyone?
7.
In the writ petition? In the writ petition,
Yes.
the respondent number 7,
Item number 19.
item number 19. There is an IA filed in 5018. You are appearing in which matter? 19. She has not been served a copy.
My lord, he is appearing in 19, my lord. I am for the 18, my lord. In it.
Huh?
IA has been filed in 18.
18.
My
No,
lord.
this is 19 and
19, my lord. 19. 19. IA.
Counsel for the petitioner will ensure service of copies of the IA on all the respondents. Matter be listed next week.
So the date may be fixed, my lord.
You want all specific details, but you are not ready when your matter is called up.
No, my lord, in fact, my lord, at that time.
Do you not know that as per the High Court rules, the basic principle is to serve copies on the other side? You are aware of that? You are ready to argue a
My lord,
matter
I-
without completing the formalities.
My lord, I will file.
And then you are insisting on dates.
And
For
I-
what purpose? We are ready to dispose of matters.
My lord,
You are not ready to urge.
My lord, on next week, my lord.
List this matter on 6th.
My lord.
You serve it by before that and we'll have it on 6th.
My lord. Obliged.
Item number 20, Lordship.
Both the matters, 1920.
Lordship, in a repetition, Lordship, the, as per office note, Lordship, service to the respondent number 5 is not completed. As the
Lordship, I am supposed to appear for respondent number 5, Lordship. I have not filed
Then
yet Okalam.
What is the meaning of supposed to? Either you appear or you don't appear.
Lordship, I have not filed it Okalam, Lordship.
So
I
you
have
file it by
instructed,
6th.
Lordship.
Then, Lordship, service is completed, Lordship.
Let it be on 6th.
Lordship.
Yes. 6th of February.
21.
Dear Lordship, my lord.
Affidavit filed.
Affidavit filed, my lord.
Do you want to file a response?
No, no, my lord, no, my.
No.
No, my
So we'll keep it for admission.
lord, my.
What is the matter about?
My lord, management, I filed a complaint before the cyber crime cell on before 3 years back. and which was not registered. And ultimately, that was forced me to file a writ petition, my lord. And the court is highly pleased to issue an instruction to seek instruction. And after that, my lord, the SSP, respondent number 3, has filed affidavit, my lord. And I just want to draw your lordship's kind attention to
Most probably, lordship, in this case, step is not complete, lordship. Service is not complete, as because in the cause list it's shown as no steps. I have not.
because, my lord, no standing counsel is available from the ICICI Bank, my lord.
You serve it on the bank. Why don't you serve it on the bank?
My lord, my lord.
4, 5, 6, 7. You have to serve it on the bank. How much time do you want?
So, subject to your lordship's convenience, my lord, subject to your lordship's.
As per office note dated
within
29
2
1
days, my lord.
2026,
Within 2
service
days
of
we will serve.
respondent 4, 5, 6, 7 is yet to be completed. Petitioner will take steps for service of notice on respondent 4, 5, 6, 7 by speed post. And within 1 week from today, matter be listed after 4 weeks. You take steps within 1 week.
My lord, my lord, my lord, please date, my lord.
Yes, after 4 weeks. 6th of March.
Highly obliged, my lord. Obliged, my lord.
Mr. H. Sharma appears for the respondent.
22. My lord, due to bona fide mistake, while step was not taken, kindly grant us 10 days time to take steps.
Mr. M.U. Mahmood, counsel for the petitioner, prays for and is granted 10 days time to take steps on respondent 6 by speed post. Mr. N. Das appears for
3, 4.
respondents 3 and 4. Mr. Dubey for
Respondent 2.
respondent 2. Let the steps be taken within 1 week. 10 days, 10 days. Given 10 days time. Matter be listed again on 27th February.
All right.
Next, please, your lordships. But in this case, your lordship was permitted to take a steps, registered post as well as Dusty Milord. Registered post also we had taken. As regard Dusty Milord, the petitioner personally went to the residence of respondent number 51 A, B, C, D, E. But they refused, Milord. Not cease from Barpeta. We will filing our affidavit in 2 days, Milords, regarding refusal. We had also taken steps by registered post also, not that there is.
Counsel for the petitioner submits that in terms of the orders passed, steps have been taken by registered post and attempt was made to serve notice by way of Dusty, but the same was refused by the respondents. The affidavit of compliance will be filed by the petitioner within
2 days, man.
Within 3 working days. Place this matter again on.
Can it be taken on Friday, my lord?
6th? No. Let it be on 11th, 9th or 11th?
9th, my lord.
9th.
Deeply.
Mr. Khaun for?
1A, 1B, 1C, and 2, 3, and 4, my lord.
1A, 1B, 1C, and 2, 3, and 4.
In fact,
2,
we had
3, and 4.
We had proposed for negotiations, Milord, settlement, but because respondent number 5 legal has been not served, Milord.
Go for mediation?
Yes, yes, Milord. We are agreeable, Milord, but for service of respondent number 5, it could not.
All right. Let there be an attempt.
Yes, yes.
On the next day.
38, 900.
Mediation or date set up mediation or কোন ডেট ওপর কোন ডেট রেফারেন্স কোন ডেট ওপর কোন ডেট মিডিয়েশন হবে আমি যদি রেফার করি we have to fix a date কোন ডেট ওর মিডিয়েশন দিতে ডিসিশন দিলে
May I please your lordship?
Yes.
As per office note 31/2026 lordship, the service upon respondent number 1 is returned back lordship. We have tried lordship to serve upon the standing council of State Bank, but they are not accepting the notice.
Go and serve on the bank.
Yes, lordship, it has been served on 27/11/2025 lordship, but they are not appearing.
No. It has come back. Notice has been received unserved.
Yes, lordship.
So you take dusty service on respondent number 4, respondent 1. Oh, this is in Maharashtra.
Yes, Lordship. We have served, our grievance is only with respondent number 2, Lordship.
You serve the notice on respondent 1 through respondent number 2.
Yes.
You take dusty service. You take service of notice on
Yes,
respondent 1 through respondent number 2.
Okay.
As per office note dated 3001/2026. Service on respondent 1 was returned with the endorsement within quotes insufficient address, no name of proper department, RTS, quotes closed. Stop. Petitioner is permitted to take steps on respondent 1 through the respondent number 2. Stop. The petitioner will enclose a copy of the order passed by the court today, along with the sufficient copies of the writ petition, along with all annexures, and serve it on respondent number 2, who in turn will ensure that the writ petition is transmitted to respondent number 1. Stop. The respondent number 2 will also file an affidavit of compliance to that effect.
But date may be fixed, Lordship.
Matter be listed on 6th of March.
Much obliged. Lordship.
Please, Lordship. The similar subject matter is pending before the Apex Court, Lordship.
What is the subject matter?
They have challenged the notification 9 of 23.
9.
9, Lordship.
What does the notification say?
Lordship, the notification has extended the time limits for issuing of notice. Lordship.
Pending before Apex Court.
Pending before Apex.
You give us the orders.
Lordship, I'll give the SLP number, Lordship.
No, you give us the status of what any orders are passed. What is the
It's
status?
pending, Lordship.
Huh?
It's pending. Notice has been issued. It's
So
pending.
whatever orders are there, you serve, you give it to the court. The counsel appearing for the respondent submits that the similar issue is pending before the Apex Court. He is therefore permitted to place before the court relevant copies of the orders or particulars of the SLP stated to be pending before the Apex Court. Mr. Arvind Misra appears for the petitioner. List on 9th.
So 25 is similar.
Order. 25 similar order.
Can it be on 10th or 11th, Lordship permits, my lord?
11th.
11th. Much
11th.
obliged.
Much of.
My pleasure, Lordship. Here, petitioner was convicted and he has already completed about 25 years of conviction, and he applied for remission. All were forwarded district judge, district magistrate, and jailer opined for his remission, my lord. But Director General of Prison rejected it on the ground that he escaped while he was on leave. But the record shows the jailer's record. He returned on time to the jail when he was on leave. Those I have annexed, my lord.
Yeah, so what is your prayer here?
Now, my prayer is that rejection order, I have sought for setting aside of that and for remission of it.
To submit, my lord, so small submission. Here it is deferred for 2 years on the stated ground, my lord. And that was done by the special committee, my lord, by 22/7/2024.
Where is
Now,
that?
Lordship,
Page 52, my lord, that rejection. Page 52, number 2, Rohim Ali. The reason for rejection, it is escape from jail for 5 years while on leave. But the jailer's record, it shows me that is not correct.
His Lordship will get it from page 49, annexure 7.
As my lord, 2 years has already been elapsed, my lord. That committee has to sit for 2 terms in July and January, my lord, as per specific notification. And in the instruction, my lord, it is stated IG present that they will submit place it on 2026. That is upcoming in July, my lord.
No, I am against that rejection, my lord, because rejection says.
You are now in prison.
Yes, my lord.
This is
Lordship
my
may
written
kindly have a look
instruction.
at page 49. It is the information submitted by jailer, who is the custodian of records of prisoners. My lord, column 7 of page 49. Recommendation of superintendent is Lord, here column 2, yes, return to district jail Golaghat on exact date. Column 2 of page 49. Whether life convict had returned to jail exactly on the date of reporting back to the jail, if not number of days of overstay. It is stated, yes, return to jail, district jail Golaghat on exact date. If jailer says, my lord, that he returned to jail on exact date, but the Director General of Prison rejected on the ground that he.
You give us the records on the basis of which this order was
Yes, ma'am.
passed.
That is required.
You have not filed any affidavits.
No, like lordship, this instruction has recently received, my lord.
Then you produce the records.
Lord.
The petitioner before the court is aggrieved by
Defer কৰিছে গতিকে next
the
place কৰিব।
It's ordered 24/10, 10/2024.
Whereby the prayer for remission of life convicts, like the petitioner, before the review board was rejected on the ground that the petitioner escaped from jail for 5 years while on leave. Stop. Counsel for the petitioner on the other end refers to a communication dated 15/6/2024, which was issued by the superintendent of the district jail Golaghat, where the petitioner was lodged for serving out his sentence. Stop referring to the same communication. Counsel for the petitioner submits that there is a specific statement that the petitioner had returned to the district jail Golaghat on the exact date he was supposed to, and there was no overstay. Stop further. The recommendation of the superintendent of the jail is in favor of the petitioner for his release from the jail, as his conduct, behavior, and performance is found to be good and satisfactory during the confinement in the jail. Stop. Learned counsel for the petitioner therefore submits that where the superintendent of the jail has given a favorable report, the review board ought not to have rejected the claim of the petitioner, ought not to have rejected the prayer of the petitioner for remission of his sentence. Stop. He further submits that going by the report of the superintendent, the finding of the review board that he had escaped from jail for 5 years while on leave appears to be incorrect. M.S. M. Borman, learned government advocate, submits on instructions that the review board has a sitting every 2 years. And the rejection of the petitioner's claim for remission was on 2024. And therefore, the review board is likely to sit again sometime during the month of July.
July, as per notification, January and July, this 2 months.
2024. The January it was not held.
Probably not,
So,
because
under
his
such
order is on 6 months.
we permit the learned government advocate produce the relevant reports before the court on the basis of which the review board rejected the prayer for remission of the writ petition. The records must also contain the comments / the recommendations of the district jailer. List again. On 9th of March.
Obliged.
9th of March.
Much.
28.
My lord, in this case, pleadings are exchanged, my lord. Lordship may fix a date for hearing.
No, no, my lord, it can be disposed of at the admission stage because lordship, my account has been freezed, lordship. My SBI, my tenant in respect of the Bonda Bank branch, your honor, Bonda branch. And lordship, both the petitioner number 1 is a widow, petitioner number 2 is unemployed. They don't have any money to even manage their 2 times meals, lordship. Whereas the more than rupees 60 lakhs is lying in my account. And these last 2 years, this writ petition was filed in 30th of March 24. So this can be disposed of, Lord.
Who is respondent 3?
Respondent number 3, lordship, she is private respondent. She is claiming that she is the second wife of late Suman Talukdar, which is absolutely false, lordship. And even the bank in a letter informed the petitioner that if the petitioner submits a succession certificate, the account will be defreezed. We submitted the succession certificate. Thereafter also the account has not been defreezed.
Why was it frozen? Why was
It was
freezed?
frozen that a letter was written by the private respondent to the bank that after the death of her husband, she is the owner of the property.
My lord, in fact, the
But that
respondent,
reason has also not been, your lordship will please to peruse the impugned order, which your lordship will find at page 85, lordship.
You are still occupying.
Yes,
Well,
yes,
I am
bank is
occupying.
occupying. They are
now,
depositing the monthly rent in my bank account, but not allowing me to draw.
Where is the agreement?
my lord, agreement is there in the writ petition.
Hmm.
It was, your lordship will find. Lord, in our affidavit also we have page 107, our affidavit, my lord, affidavit in opposition. What is it? Suman Talukdar was the owner of the land, my lord, as well as the building constructed thereon.
Oh,
We are in occupation in the first floor of the building, my lord. As a tenant, we are running bank business over there as State Bank of India. My lord, Bonda branch.
the lease
Now,
for how many years?
My lord, it was leased for initially
From 2018, September, lordship. Page
25th
106.
of September 2018, my lord. And now, my lord, dispute is with regard to the ownership of the land, my lord.
Respondent
This-
number 3, Lordship did not, in spite of service of the
This-
notice, did not appear, did not file any affidavit in opposition, Lordship.
My lord,
This agreement was filed, was valid till which date? 106,
for 3 years, my lord. Thereafter,
3 years.
my lord.
Then what happened?
Thereafter, he died, my lord. This Saman Talukdar, he died
He died.
due to illness,
Then,
due to kidney problem
then
and all.
no renewal.
That thereafter no renewal.
Then how are you occupying the property?
My lord, as a statutory tenant under the Assam Rent Control Act, my lord, even if there is no, my lord, agreement, my lord, I am a statutory tenant, provided I am paying rent. My lord, even because, my lord, now there is a dispute in between the, my lord, the second wife and the first, and the
So,
mother and
You are
the
not
and
to-
the son.
You are not to decide the dispute.
My lord, that is
Dispute
what
to
I
be
am
decided
submitting.
by the
Civil court.
competent jurisdiction.
Civil court, correct, my lord.
Then
Civil court, now cases are pending before the civil court.
account, in the bank account, is there any nominee?
My lord,
In the bank account, there must be a nominee.
there is a nominee, my lord,
then-
but if, my lord, the ownership of
So
the
then
property,
What is the point in having a nominee if you are now questioning the ownership?
my lord, the respondent number 3, now she is claiming, my lord, then she is the owner of the property
Is it under the,
and she filed a suit for eviction against us, my lord, claiming the area rent.
then
Now, my lord, the question is, to whom should we pay? It is in our custody, my lord.
you pay
The
to
moment-
anybody, but on what basis are you freezing the account when there is a nominee?
No, my lord, we'll have to take in instruction, my lord, whether there is any
You
nominee
have
and
filed your
under which
affidavit, you say the
I'll-
matter is ready.
Always my letter
I'll-
friend, your Lordship,
No,
on
I'll-
the day of
I'll-
admission
I'll
hearing,
say,
took
my lord,
time.
Who was the nominee of Suman Talukdar?
Nominee is the, Suman Talukdar wife, Barnali
that is
petitioner
not-
number
that-
two.
You get the records from the bank, let us see. Account, who is the nominee?
We have submitted the succession certificate,
nominee is
Lordship.
all right, my lord. That is so far as area rent is
No,
concerned. My
not
lord,
really.
now,
It's a question of operating the bank account.
my lord,
This is not your money. This is the money of the customer.
yes,
On what basis are you freezing it?
we are ready to pay it, my lord, but to whom we shall pay? That
To
is
the
the question,
nominee.
my lord. To the
Lordship,
nominee.
they are
Why
depositing.
why have you asked the customer to go for this KYC and fill up the bank, these documents, if you don't want to give?
My lord,
Do you credit to your formats, your regulations?
Lordship,
My
the
lord,
bank
now-
is depositing
now-
the monthly rent in the bank account of the petitioner number 2,
Oh,
but not allowing me to draw the money.
then
because, my lord, third party, second wife is claiming the, my lord,
Still a
said rent.
claim, but is there any authority of law to say that it is by a order of a civil court or high court or some other court saying that she is the owner?
In civil court, there is a status
What
quo
is-
order.
What is the status?
Civil suit filed by them, my lord.
Status quo is in respect of eviction.
In
Ejectment.
in
The
respect
status
of
quo
the
order is,
suit
Lordship,
property.
not to alienate or transfer the property,
Property.
except that there is nothing.
Now,
I have
they are-
annexed the injunction order.
Who has filed the suit?
I have filed the suit
Initially, they have
because
filed the
the
suit.
respondent number 3, she is a trespasser, Lordship.
Hmm.
She was never the wife, private respondent, never the second wife, Lordship. She is a lady down, Lordship. She occupied
My lord-
possibly the ground floor.
Where
As well-
is the where is the injunction order?
Injunction
Yes,
order,
yes,
Lordship.
Yes, they have, my lord, I have placed it, my lord, page 133. Page 132 is the, my lord, order dated 2/6/2022.
133.
My lord, 130, it starts from 132.
And bank is
Then
not a
after-
party to this suit.
Correct, but subsequently, my lord, this Mamoni Devi, respondent number 3, has filed a suit against us, my lord,
What is the order there?
for recovery of her rent. Order is, my lord, your lordship will find. From the aforesaid pleadings on record, it is seen that the petitioners are claiming that the OP is the encroacher over the suit property, and per contra, the OP claimed that she is legally wedded wife of late Shuman Talukdar.
You are reading from which?
My lord, page 133 of my affidavit in
So
affidavit.
this is in the suit filed by them.
By them,
petitioner.
by them.
What about the suit filed by respondent 3 against you?
Yes, that, my lord, we have filed our additional affidavit, my lord. In our additional affidavit, we have stated, my lord.
There is no injunction order, nothing, Lordship.
Then
My lord, your lordship kindly see, my lord, then next page, page 135, my lord. And there are, my lord, multiple litigation in between the.
where is the restraint order by the court that you are not supposed to release it? Show us.
So far as rent is concerned, my lord.
So far as using the usage of the account is concerned.
That,
There
my
is
lord,
nothing, Lord.
no, in that suit, my lord, the court did not pass any
No,
order.
not in that suit or this suit, in any suit you show us. Where is that order? Where is the order restraining the bank that you are not to allow usage of this bank account? In spite of there being a nominee.
My lord,
This is nothing but out and out deficiency of service.
My lord, using of a banking account is no bar, my lord. Only
but you have
to, only,
chosen it.
there are multiple transactions in the bank account, my lord. Only the rent deposited in the account has not been allowed to withdraw. Because of the fact that there is a, my lord, multiple claim over the
Maybe,
rent, my
but
lord.
unless there is a restraint, how can you restrict the lawful
Account holder.
customer account holder?
Because there, we have certain, my lord, guidelines or, my lord,
If somebody
standing orders.
files a suit, you will wait for eternity. Who is the customer? Who is your customer?
Obviously, my lord, Darshan, my lord, the Darshan Talukdar now.
Then?
Darshan Talukdar is the customer. We are depositing the rent. It's not the fact, my lord, that we are not paying rent. We are depositing the rent, and because, my lord, this respondent number 3, she has filed the, my lord, civil suit, my lord, against us for recovery of area rent as well as, my lord, eviction from the suit premises. My lord, in that suit, they have also been made party. And we have filed our written statement.
Is there any order? You are an
Well,
active counsel.
that particular order is not there.
Not there, then why are you restraining
It's
it?
not there, but, my lord,
Under
tomorrow.
what authority of law are you restraining it? That is
My
what we want
lord,
to know.
under obligation, if there is any court proceeding is pending, my lord, then, my lord, we are under obligation to freeze the
Absolutely
account. My
incorrect
lord,
submission,
my lord,
absolutely
that,
incorrect.
that is what, my lord, I have, in my additional affidavit, I have stated, my lord.
This is ridiculous that you are withholding the functioning of the bank account without, on the ground that some litigation is pending, and you are merrily occupying the property. You vacate the property. Why don't you vacate the property?
I'll vacate. We are trying to vacate, my lord,
Trying?
because of this dispute, my lord, we do not want to, my lord, carry on our
You
business.
call
my
your
lord,
manager, we'll ask him, what are the principles on the basis of which, on what regulations do you have to withhold the usage of the bank account?
because, my lord, the obligation.
Show
my lord,
us under
yes,
what
my lord,
rules?
yes, my lord.
Under what rules? What obligation you have? Somebody makes a claim without any sanctity of any
My lord,
judicial order.
102, page number 102, paragraph,
Which petition?
paragraph 14, my lord, of our
Your affidavit statements are irrelevant. You show us your terms and conditions of the account uses. Where does it say?
I'll produce, my lord, on the next day, my lord.
And if we find that it is not there, we are going to issue strictures against your officers. We are putting you to notice.
No, my lord,
This is no way to conduct business.
no, my lord, because, my lord, why, my lord?
No, no, no,
Because
we don't-
tomorrow, my lord.
We
if-
know tomorrow, day after, somebody will make some allegation against you. If you are so scared, don't be in the banking business.
My lord, what I am submitting. my lord,
Resign from your service.
What I am submitting, my lord,
Huh.
today, if we allow them to withdraw, and tomorrow, my lord, if
Are
civil court says,
bound by a set of rules and regulations.
my lord,
You show us these rules and regulations that under such circumstances, you are entitled to restrain usage of the bank account, and the customer has been already put to notice at the time of opening the bank account. You show us those details.
I'll provide, I'll.
Yes, you do it on 6th.
Can it be on 9th, my lord, 9th?
Yes, 9th.
9th.
The stand of the private respondent as given by the bank is lordship that she got the property by an affidavit. That is on record. Bank has.
My lord, now she is in occupation. Fact of the matter is that she is in occupation of the suit premises. In the ground floor.
Electricity connection,
in
water
the-
connection.
In the ground floor and in the first floor, they are there. They are not in occupation. Now Mamuni Devi, she is in occupation and she is troubling us, my lord, like anything.
So she is troubling you, so you're freezing the account of somebody else.
My lord, to that effect, I'll satisfy, my lord,
Ah.
as to how we have, my lord,
Heard
frozen
Mr.
that.
S.P. Roy, Learned Counsel, Mr. Counsel so-and-so appearing for PK Sen for SBI.
My lord.
Mr. Sen is permitted to obtain his required instructions in the matter as to why the bank account of the petitioner has been freezed and the petitioner is not permitted to operate the bank account. Let these instructions be placed before the court on 9th. On 9th of February. Placed accordingly. On 9th.
Lordship, I think it will be proper to call the bank branch manager.
No, my lord, it's not.
Just find out.
Let us.
What is happening?
Yes.
Yes, yes.
We have put to challenge the disciplinary proceeding and suspend order of suspension, your lordship.
Disciplinary proceeding, why is it here? Service matter?
That I don't know.
My lord, maybe it was like on the last occasion, my lord has heard this at length. Though part heard is not categorically, my lord, reflected.
They should go before the appropriate bench.
Lordship.
This matter pertains to civil bench 3. Therefore, registry to verify and place it before the appropriate bench.
No problem.
WBC 506 of 2026. Yes.
Please, your lordship. Lordship, hearing the petitioner is a resident of a village called Madhurband in Sribhumi district, lordship. And our claim is that we are residing on revenue land, lordship, but we have received notices from the forest department saying that it is forest land. Prior to this litigation also, lordship, there was similar notices issued to us and we had approached this honorable court along with multiple other petitioners, lordship. And there was an order in that case on 12/1/2024, which is at page number 48, lordship.
What was the direction?
The direction is at page, paragraph 6 at page 49, lordship.
Then what happened?
There was a direction to conduct a verification taking us into confidence, lordship, but there has not been any verification yet conducted, lordship.
Yes, Mr.
My lord, contrary to that, my lord, I have received my instructions. My lord. We had conducted one joint verification process. And we, my lord, longitude and latitude, my lord, they have found to be inside the forest, my lord.
They are supposed to be inside.
They are inside the forest, my lord.
So therefore they cannot be evicted.
They'll be evicted.
Oh, they'll be evicted.
They'll be evicted.
Okay. They are not forest dwellers.
No, my lord. In fact, after receiving notices, my lord, they didn't. In fact, this my drawback, I can provide the color map. Otherwise, the pinpoints they are located inside the forest, my lord. Look. No, go ahead. I tried to point my lord with blue pen, my lord.
Petitioners were permitted to be present.
Yes, lord.
No, petitioners were permitted to be present in the verification.
That joint verification, these joint verification, they are not allowed, my lord.
That's what the direction of the court says.
But 251, we resorted to 251, my lord.
No, you have to resort to the order passed in 12-1.
But this is under dispute, my lord. We have, our records don't reveal that this kind of order was passed, this kind of order was communicated to us, our office.
Yeah.
This single judge
You are
order.
represented by counsel.
Yes, my lord.
Huh.
But they should have gone there, my lord, because we tried to, but there's
You
no
are
response.
represented by counsel. Why should they take the trouble to inform you? What is the purpose of having us forest counsel?
That I understand, my lord, but my office does, our office doesn't have this.
If it doesn't have,
Yes.
then you have to recall this order and do it again.
We'll do it, my lord, we'll do it.
Huh?
It will be like order passed in my lord, supplementary 31. Similar orders, my lord.
Supplementary 31, I
31.
don't know what order was passed.
No, that might be forest village or whatever, my lord, but order was, the lordship had passed a direction to go for a joint verification, which will include them also. So this covers them, but this is not a forest village, but to their satisfaction, we'll call them also.
No, it's not satisfaction. Do you dispute that they had come before the court in 159?
No. We don't dispute that.
So the one order in 159 made it very clear that officials shall permit petitioners through a representative to be present.
My lord.
So that if it was not done, then
That I won't like to comment upon further. But lordship can very well dispose it off with the directions passed in that item 31. We can go for and give them a chance.
so how much time is necessary?
There are only 17 persons, my lord. Can do it within a week, my lords.
I don't know what order was passed.
Lordship, that my senior had appeared and there was forest villagers, they went beyond the allotted
Unless I
land.
see the order, I'll not recollect.
My lordship may pass a similar order as it is here, directing the revenue department officials and the forest department officials along with us to verify lordship.
Already verified, my lords. Now only the forest has to act
Alright,
upon it.
disposed.
My
We'll
lords.
take the order at
My lords.
31.
My lords. 31.
Just that in that case, it was purely forest land lordship.
No, this is
revenue
also forest
not,
land.
involved.
Even this is the forest.
Disposed.
Right. Published.
Much obliged.
Huh? 11 over 350 people are in here. Any other matters will be taken up on some other day. We have a different bench. You have a matter?
No, I'm just